Are we all here? Certainly, Mr. Cole is here. As I understand it, Mr. Cole, you are going to be responding to allegations by Mbalati, Lona Botsotobe, and Alviro Peterson, or some of them.
Yes, correct.
Yes. I will ask all of us to place ourselves on record. But Mr. Cole, do you prefer to take the oath, or are you going to affirm?
I'll take the oath.
Take the oath. Let me get that out of the way, and then we can formalize our afternoon's proceedings. Mr. Louis Cole, Mr. Louis John Cole, do you swear that the evidence you are going to give me over and above what you have given to me in over 300 paragraphs of your affidavit is the truth, the whole truth, and nothing else but the truth? And if that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much, Mr. Cole. You are now sworn in. You know Mr. July, who's sitting to my right today for reasons I do not know. Maybe it is now reflective of his politics.
I've seen him.
And yeah, you are familiar with Advocate Mele.
I've seen him as well, sir.
Yes, yeah. You, as I indicated, you have put in quite a number of paragraphs of affidavit. And do you also want to place yourself on record?
Yes, Mr. Chairman, I'm Aslam Musaji from ENS Africa Attorneys, and I'm assisted today by Helena Graham, who's also from our office.
Thank you very much. I wanted you to again pronounce your surname. Musaji.
Musaji, yes.
Because I always go Musaji. I said, no, it doesn't sound like it. Yeah, Musaji. And who is with you?
Helena Graham.
Oh, yes. Yeah. Welcome, Alina Graham. Yes. Mr. Cole, you have put, as I say, over 300 pages of affidavit. I believe there's also a video.
That's correct.
Yes.
Yes. I don't think it will harm me if I'm made to be aware what the intention is. But how long is the video?
It's about a half an hour.
No, it's okay. So, how do you propose to proceed with
Mr. Chairman, with your permission, if I can lead him, and I will then also indicate to the technical team when we'd like the video to be played.
That's perfectly okay. Do you have any objection? Yeah.
No objections, Chair.
Thank you. Thank you.
Thank you.
Yes.
Mr. Cole, you deposed to an affidavit on the 13th of September 2021, and that was delivered to the Ombudsman office. That's correct?
That's correct, sir.
Thank you.
Oh, have we taken the oath? Or?
Yes.
Oh, yes.
Who are you employed by, Mr. Cole?
I'm employed by Cricket South Africa.
Since when have you been employed by Cricket South Africa?
About January of 2015.
January 2015.
January 2015.
Okay. What is your job title?
I'm the designated anti-corruption officer for CSA.
All right. Why have you submitted an affidavit to these hearings?
Mr. Ombud, if I must confess that I'm a bit uncomfortable about testifying before these hearings for various reasons. Other than what Mr. Fall said, that he was scared of you.
Well, if that is one of the reasons you might be uncomfortable, I don't bite.
I trust you, sir. So after the players had been banned over a period of time, there was a clamour amongst the media to understand what had happened and who was behind the investigation. And obviously, because of the CSA media policy, I was advised by Mr. Lorgat, who was the CEO at the time, not to appear because the investigator just doesn't appear in a public space. And but the reason why I'm here today, sir, is I owe it to a lot of people to explain what had happened and what led to the players being banned. And I owe it to this ICC, the CSA, my colleagues and players that I've been working with for the past 6 years, to explain to them what it is that had happened. So I'm thankful for the opportunity that you've given us to give our side of the story. It is unfortunately going to be a laborious process. The 300 pages that you got, or the paragraphs that you got, is unfortunately just a short summary of the investigation, but Mr. Umusaji insisted that I keep it as short as possible. But that's the best I could do. Secondly, so I find myself in a very precarious position in that I have to testify under oath about what had happened. My submission is under oath, and it deals with the very same facts that I have to testify to under oath in a criminal trial. So it is a very difficult thing for me. I've had to consult with the investigating officer and with the NPA to find out, can I testify to what I have? Because obviously the criminal case is ongoing. So I find myself in a very difficult situation. The allegations that had been made by certain individuals before the SJN are very serious. And if I can just shortly summarize them, is that Mr. Beck and I, on behalf of CSA, had been accused that we had threatened players and their lawyers, that we had coerced them to sign the affidavits, that we imposed severe sanctions on them without any evidence being produced, that we followed a procedurally unfair process. And then for me, the most serious allegation is that we targeted the players on racial grounds. The allegations are so serious that CSA should dismiss me if they were found to be true, because there can be no place in our society, and let alone in an environment, anti-corruption environment, where I am the person entrusted to enforce the anti-corruption code, or the provisions of the anti-corruption code. So I consider them to be very serious, and I absolutely have to respond to that. Even though I'm a private person, I don't like being in the public space. I feel I owe it to everybody to give a fair account of what had happened. I think it's also important to understand that an investigation under the code is a highly regulated process within a system of oversight. And it is dictated by CSA policies and regulations, the anti-corruption code, the code of ethics, and the code of conduct. It is also guided by our the laws of the country and the constitution. I cannot do what I want to because there's an oversight and there are parameters within which I have to operate. And over and above that, an investigation is under severe scrutiny of various levels of oversight. The CSA board, the ICC, the respective heads of investigations, intelligence, and also legal, who we had to report to in terms of the progress that we had to give. And then what would eventually follow an investigation would inevitably lead to either criminal or civil proceedings or disciplinary proceedings. It is the logical end game of any investigation. That is where it will lead to. So conducting an investigation, I have to keep all of those things in mind, because I will be caught out when we get to a tribunal and it is found that I have not followed process which is prescribed in the Anti-Corruption Code. Now, there's been a perception which has been created by the complainants in this case before the SJN that we basically conducted a rogue and a racist unit or investigation. And whilst it is hurtful, I have to account because they have their own reasons why they would allege that. And in the anti-corruption environment, so integrity is a prerequisite to function in that. I have to give anti-corruption education to the players, which I've done recently in the tournament that has just ended, where I have to say to them that the provisions of the code requires you to do X, Y, and Z. And I must say that my discomfort during these around about 25 sessions that I conducted now was the elephant in the room, and that was me, that is being accused of violating the provisions of that code. It was very uncomfortable for me because a lot of players actually questioned me with good intentions to say, what are these stories that are being bandied around about the process that we've followed that seems to be so corrupt? But it is not something that one can run away from and that one has to confront, because that's the environment that I operate within. Now, there's one thing, Mr. Ombudsman, that I just need to get off my chest, and please correct me if I'm wrong, but it is not an anxiety, but it is something that has bothered me since it came about. It is the fact that people who respond to these questions are being referred to as perpetrators in the terms of reference and also in media, in television interviews. For me, it is just wrong, because the word perpetrator implies guilt. It undermines the principle of the presumption of innocence before our law. It implies that one has been found guilty before your side has been heard. And it is just the furthest from the truth. I would accept that if it was named an alleged perpetrator. But I'm here today as a witness or respondent, certainly not as a perpetrator, and I will never accept that until I've been found guilty. Having got that off my chest, I feel a lot better and I'm ready to go.
Okay. Thank you, Mr. Cole.
Just before you go in, Mr. Cole, I just want to say at this stage, my reading of the terms of reference of this project, and my legal advisor, Advocate Mele, has heavily drawn my attention to paragraph 4 thereof, where it, under the heading responsibility of the Ombudsman, 4.1.1 talks about the Ombudsman being responsible for the following in discharging his obligations, and then 4.1.1 says conducting evidence gathering exercises from both victims and alleged perpetrators.
Stand corrected, sir.
So if that comforts you, there's the presumption of innocence in my view. Cursory glance of the terms of reference seems to have been taken care of.
I'm happy with that.
Yes.
I'm just mindful of the perception that has been created, and that people have feel that have to come. But I accept that.
So if the players are watching, they will know that I have said to you they shouldn't take a view of you without giving you the benefit of the presumption of
Thank you,
your
sir.
innocence to the extent that it might be affected by the process. Yes.
Sorry,
Yes, Mr. Session.
Mr. Cole, in paragraph 5 of your affidavit, you deal with the International Cricket Council's anti-corruption code as well as the Cricket South Africa's anti-corruption code. Can you just take the Ombudsman through
Can
that,
I just
please?
go to paragraph 5, sir? 4.
It's on page 2.
Yes,
of
I've got
your
the text.
affidavit.
Can you just repeat the question? I was
So I just wanted you to take the Ombudsman through the International Cricket Council's code and CSA's code.
Mr. Ahmed, I've been in the investigation. I've been in the fortunate situation that Mr. Becker at the time was the head of legal at the ICC, and he was responsible for drafting or assisting with the draft of the ICC code. And then in 2015, just after I'd started, the ICC had conducted, they established a group called the Integrity Working Group that was established to coordinate all the anti-corruption activities in South Africa, around the world, and to sort of coordinate them. And they released a set of recommendations. One of the recommendations was that each member country had to establish an anti-corruption code unit, as well as an anti-corruption code. And subsequent to that, I was then tasked to draw up the CSA anti-corruption code, which was then, I think, adopted by CSA in September or so in 2015. In 2015.
You say that code was adopted in September 2015, but when did the training of players in relation to anti-corruption start?
Prior to my employment by CSA, the anti-corruption education had really been conducted by the ICC anti-corruption manager for international tours, and domestically SACA were really responsible for that. But after I'd started, I used the ICC code as a draft, and I started training players on the draft, which basically is a copy of the ICC code. Just the jurisdictions differ.
Then in paragraph 6 of your affidavit, you deal with CSA's anti-corruption unit. Can you please tell us about that unit?
As I referenced earlier, CSA is an anti-corruption unit, and it was constituted in terms of an agreement between the ICC and CSA and all other boards, but for South Africa, it pertained to CSA. And it was meant to, the unit was meant to prevent and combat and investigate corruption in domestic cricket. That was our jurisdiction. Must I deal with the corruption section there, or will you leave me to that?
I'll take you to that. In paragraph 8, you then talk about the Integrity Working Party. Tell us what the Integrity Working Party is.
As referred to, it was a group of persons constituted by the ICC, and their task really was to establish a set of recommendations to coordinate anti-corruption activities across the world. And one of those recommendations that they came up, I think there were about 24, was to set up an anti-corruption unit, and subsequent to that, the anti-corruption code.
Okay. In paragraph 10, you deal with your duties as an anti-corruption officer. Please take us through those duties.
So my duties are to conduct anti-corruption education programs, which I just alluded to. It's also to ensure that the integrity of the game, of cricket, of the domestic game, is protected, and by investigating any allegation of corruption or corrupt approaches. Secondly, I was tasked to implement a set of minimum standards for players and match official areas. Basically, on match day, there are a set of guidelines which they have to adhere to ensure that corruptors do not get to them. I am also tasked to set up a regulatory framework and to maintain that, and then to provide the CEO of Cricket South Africa with strategic guidance on issues of corruption.
Mr. Cole, you mentioned that you had to provide education to players. Was the provision of education limited to the players?
No, it wasn't. It's also all participants, which is described in the Anti-Corruption Code, and that would include match officials, any official working for Cricket South Africa, and on match day, any of those. It applies to all of them.
Okay. In paragraph 11, you referred to the adoption of the Anti-Corruption Code by Cricket South Africa. Please take us through that.
That went through quite a process where I had to draft, and there was quite intensive consultation between myself and the ICC head of legal, where it would be a to and fro with the draft until it was finalized. It then had to go through a process within Cricket South Africa where it was officially adopted as a policy. I'm the owner of that document in September of 2015.
Then in paragraphs 12 to 16 of your affidavit, you deal with match fixing and spot fixing. I'm going to ask you to take us through that, but in taking us through that, can you also emphasize what the differences are between match fixing and spot fixing?
So, Ahmed, match fixing and spot fixing, there's a clear difference between that. But the players and maybe myself today, I'll use the term match fixing interchangeable with spot fixing. But match fixing or corruption in cricket takes the form of match fixing. Match fixing is where there's an attempt to manipulate the outcome of the game. In other words, who's going to win and who's going to lose. Spot fixing, for example, let me just go back to the match fixing. It is made a lot easier when a corrupter, a middleman, for example, recruits many players in one team, and preferably the captain, where a lot of players can then, in conjunction with each other, manipulate the result of the match. So it's very difficult if you only have one player, because of the length of the game and the complexities of it, to manipulate the outcome of the game if you only have one player. Spot fixing, however, is where they attempt to manipulate an incident within the game. In other words, for a bowler, it might say that in the 6th over you have to bowl a wide, or you have to bowl a no ball, or you have to concede a set amount of runs in that particular over. For example, 14 or between 14 and 18, whatever the case may be. For a batsman, it might be where they say you've got to bat slowly so that you bat at a runner ball. In other words, if there are 6 balls in an over, that whatever length of time you bat, that you just make sure that the runs you scored equals the amount of balls that you faced.
Then in paragraph 17 of the code, you set out what is prohibited under the code. I'm not going to go into all of those details, but I just want you to emphasize the fact that it's not just corruption that is targeted. There are other obligations on the participants. Can you take us through that, please?
The most serious charge which a player can face would be an offence which amounts to corruption. And the second one is betting. Players are not allowed to bet on any aspect of a game. They're also not allowed to use or misuse inside information. For example, who bats at what number, who's injured, what bowler will bowl which over. Those are examples of what they may or may not do. And then one of the failing to disclose an approach or knowledge of an approach of that player or any other player is also an offence, and those were typically most of the offences which these players have made themselves guilty of over a period of time. And then obviously failing to cooperate with the anti-corruption officer is an offence in terms of the code. And then obstructing or delaying any investigation is also a problem, an offence, and this is also one of the aspects where the players made themselves guilty, where they deleted their phones and information on their phones, etc.
Mr. Cole, I understand that you now want to play a video recording. Just before we get the technical people to play the recording for us, can you just explain to us why you want that recording played?
for me, it was very important, sir, to play these videos. What I'd done in the course of my investigation with each interview that we had, as you will see on the video, is Mr. Beck and I convened meetings with the players in a similar setting to this, where the players' lawyers were present, and we would ask them for a set questions, and then convene later meetings with them to follow up on information like that. And the video says in their own words what had happened. It also indicates the interaction that we had with the players and with their lawyers, which might rebut or confirm the allegations that had been made. It indicates the inquisitorial process that we followed, similar to this, where we asked questions, got it, and then said that it doesn't match up with the evidence that we have. I also have a video of one of the corruptors that I went to go and see in India, and he gave me an account of what had happened when he was in South Africa. And it confirms meetings that I had with the players that refers to the same incident from Mr. Bodie and two or so of the others.
Mr. Cole, we'll get into the relevant detail when we'll go through your chronology. I suggest you just move over and sit on the left-hand side so that the Ombudsman has a clear view of the recording, and let's play the recording, please.
The first part is an instructional video where it just shows what they do.
As a global players' body, FICA wants you all to have successful cricket careers and to be the best you possibly can be. There are people out there who threaten your careers and the integrity of our sport. We must identify those seeking to exploit cricket and together stand against them to keep our game clean.
And at the end of the meeting, the guy just pulled out some money and said, "Thanks for meeting us. This is just to say thanks," and he gave me the money. I thought it was a bit odd, but I mean, I just took the money. Suppose I shouldn't have. I didn't report the incident, and I accepted money from them. So that all led to me being investigated and ultimately sanctioned by CSA.
We've seen the consequences for people who have fixed matches, life bans and even imprisonment. This may seem far removed, but everything starts somewhere, and you should understand that you or your teammates could be approached. It's simple, really. Don't fix a match or any part of a match, and you must report approaches, suspicious acts, or any concerns to your governing body's anti-corruption unit and cooperate with any investigation. Let's leave cricket in the right place for generations to come. Help protect our game. Inside information is information that is not known to the public, but is known to a person because of his or her position. As a participant, you are not allowed to use inside information to place bets. And you can't pass information to a person when you knew or should have known that person would use the information for betting.
We play Sunday, then the next 5 games, 4 of 5 games, they hold. The next 4 games we're going to be playing at home.
Wow, what do you have got for us now?
In terms of?
In terms of like the players.
The players. You see, at the moment, like I'm talking about the definites now. Mm-hmm. At the moment, it's me and Lopsy. Mm-hmm. It's me and Lopsy. And Eddie, see, Pumi. Yeah. Pumi's in. So now I'm giving you the definites. The definites, guys, is
Pumi
me.
Is in for sure.
Pumi's in for sure. Lopsy's in.
Yeah.
Sams is in, but with Sams, let's leave him away, because I don't think he's going to play.
All right.
Sams, Pumi, if it's Pumi's fit, he will play.
Is that when you went to South Africa and you met with Gulum Bodie and you met certain players in South Africa and money was paid by Gulum Bodie to the players?
Pumelela, this keeper,
Yeah.
this Osobe, Elvino.
Okay. 220,000 for
1, 2,
yeah.
3. 1, 2,
So
and 3.
okay, so photo 4, photo 5, photo 6.
Yeah, 4, 5, 6.
Those 3 players.
Yeah.
During these few days in South Africa, I remember that Gulam Bodhi and I met with Longwabo Tsobi and Tammy Tosaliki. He's the wicketkeeper, yeah. Gulam Bodhi came to the Silver Star to pick me up, and we drove to an apartment where we met Longwabo Tsobi and Tammy Tosaliki. Bodhi told me that both players were ready to fix. I think he mentioned that it was agreed they'd get more money after the game if the fix went through.
220
yeah, Bodhi explained to them what they had to do. And then I put here, I agree with Gulam Bodhi that the total money to be paid to the three players, namely Alvira Peterson, Longwabo Tsobi and Tammy Tosaliki, the wicketkeeper, was going to be 220,000 South African rand.
After the
if the fixes went through. Tsobi, the bowler, was to concede more than about 12 runs in a specific over, although the specific over and the number of runs would be finalised just before the match. That's correct.
Yeah. Yeah. It's not 12, it's above 10.
About 10.
Above 10.
What was Tammy supposed to do, the wicketkeeper?
When he will come to the bat,
yes,
he will score slowly.
Okay.
He will never get out, but he will play slowly.
Tell us in your own words.
Look, whatever, the player's name I mentioned to you, who I've approached, right? Apart from Vaughan and Craig, that's all working. In that circle, where I was the number 7 person, Eddie, Lopsy, Ami, Umi, Samji, Alviro. 6 of us and me 7.
Unfortunately, it's important because what you're saying to us now is that each one of those other players, besides Vaughan and Craig, were keen. That's what you just said.
Yes, they were keen. So the last 3 players who we just discussed, Vaughan, Craig and Alviro. Okay? You can clearly see there's been a no from Craig, there's been a no from Vaughan, and then here when the man's negotiating, then there's attempt. There's an attempt. Same thing when I spoke to Gumi and I spoke to Samji about, I spoke to Ati about, and X over, you're going to go for this much.
Yeah.
This is a sign, you must, the sign obviously involved.
Based on what you're telling us now, you mentioned the $2,500 again to Eti and the watch. Right? And what did he say when you mentioned that? Because I don't want to put words in your mouth, you must tell me what he said.
Honestly, if you are skinny.
Yeah, so you took him up to meet them, same formula?
Same formula, anything,
Did Vicky explain to Eti what he was required to do?
Yeah.
In detail?
In detail, yes. Right.
Did he receive 30,000 again?
Eti got given dollars.
And you also met with Eti Lati?
Yeah.
Where did you see him? At Silver Star?
At Silver Star. He was, and so what happened? He was the only person from the other team.
Was he paid money by Bodhi?
So whatever money I had not paid him, Gulam had paid him because we doesn't require any person, one person from one team.
Evidence that we have appears to not to support that particular version. And I'm going to give you a summary of some of that information we have.
While we were having lunch, I said to him, look, Tommy, I've got some people in India, and this is the offer they've put up. And if you're keen, obviously, look, you could be the main person because you're a captain. Like 600,000 rand, $50,000, equivalent to 600,000 rand. I was going to get $50,000 for just making decision.
That was his job.
And if he's betting, which is highly unlikely, because he bets low down the order. So if he gets a chance to bet in the 9th and the 10th over, and if he wants to, that's extra 50 is in, but my commission, I told him, He said, no, I'm doing the bulk of the thing, right? My reputation, I'm the one who's playing everything, and you can't get 20%. I said 20%. No.
The first thing he said, Ara, come on, you're the captain. You're the captain. And Alvaro is in. You mentioned Alvaro's name. That Alvaro was in.
In for what?
In for sport fixing. Right. Then he mentioned, when he said Alvaro, he said Alvaro's name was in. And then he said, Pumi Machikwe. And then when he left, and then he said to me, I was going to speak to Alvaro to speak to me. Yeah. Then Alvaro gave me a call.
What did you say? What was your response to Mr. Bodie at the one?
No, and then he said to me, when he said Alvaro was in, I said to him, I don't want to talk here because this is during practice time.
20 to 30%. He said, no, we must. What I'll do is, I'll get you Lopsy.
He said that?
Yeah. I'll get you Lopsy and Viley. Who? Alvaro. So I said, look, if you get me those two guys, give me whatever you want. Because then we'll cover it up with those guys.
And for that he was going to get how much?
$50,000. Lopsy got 60.
Yeah, okay.
Tommy got 75. Sorry.
75?
Yeah. Because he was a captain.
Did he take it out of the safe again?
Yeah, at that time he had cash. Yeah.
Then I've spoken to Alvaro about the first time at Nando's. Went to Nando's at Wonders, and then he started talking to me about Gulames. Gulames approached him in, so I asked him what do you think about it. He said it was in. He was in. Yeah. Then obviously I was quite curious about. I've never been approached. Although as a skater, I know what is match fixing. Yeah. But
and he came up straight up front and he said, I met with Indians. Gulam introduced him. They called the big guys, 5 of them, and they gave him 75,000 rand. And then he explained to me about the whole match fixing thing. Well, he said what it is that for the Ram Slam, they want to obviously fix the matches.
Yeah. So once Tommy made sure he was in, then I messaged Alvaro to say, listen, we need to talk. Let's meet up. Umi, Etty, Tommy, and Lopsy. So these are the guys who I've spoken to. The rest of all the guys are in. I need to know what's your decision. He says, I got 15,000 rand from Tommy.
Tommy had contacted you, and he
told me Alvaro was in.
That was a few.
What Manish was trying to do is
get him to
underperform, also in a way that the match can be lost also. So Manish introduced him to Alvaro.
Yeah.
You have to bat slowly, and your strike rate has to be, if you face 30 balls, even if you score 15 runs. And Manish said 220,000 I'll give you per job. Of which Manish said, I've got 50,000 in now. I'll give you deposit. He'll give you 170 balance after the game. David, from day one, he knew exactly what we're getting into. Okay? So he took the offer. He didn't take the money, but he took the offer. He said,
Alvaro was drinking beer when we arrived. It was a short meeting lasting only a few minutes. The main discussion was about match fixing. Alvaro was actively involved in this discussion and about what he could do as part of the fix. Is that all correct? The sole purpose of our meeting that evening was to discuss fixing in the Ram Slam 2015 matches. Alvaro confirmed that he wanted in and that he would do it.
Yeah.
It was discussed that Alvaro would not score many runs and would score slowly.
No, he can score more runs, but he have to score slow. In 50 balls, 50 runs, no issue, like that.
Right. I recall that Gulambodi said something to Alvaro that this would help with money for his cricket academy, but there was no discussion about me investing in his cricket academy.
It was 110. It was just for the show.
Yeah.
I would never invest in my life.
So you had your initial meeting with Tommy at the Nando's. You agreed that you would work together on this in the sense that he would try and recruit Lopsy.
Yeah.
Okay.
Tommy phoned me to say, I must phone Lopsy. An Indian's way. So I phoned Lopsy. Come and meet them. He said, at this particular time. Lopsy came and met them in a hotel. Same procedure. Lopsy was given 60,000 rand.
There are elements, the police are also interested in this case for different reasons in a way, because they have there's a Prevention of Corrupt Practices Act as well, which they're interested in following up. But for our purposes today, we're dealing with this under the code. Okay. So you saying that just out of the blue, you just said, would you guys be interested in fixing?
Yeah.
Out of the blue, you just said. And what was your response?
Well, I just laughed. I didn't even entertain it. I just laughed. He did say that in match fixing you can, I think for 1 over you can get 700,000 or 600,000, something like that.
To do what?
To fix a game.
Yeah.
No, he just said you can get 700,000 and that's it.
In 1 over.
In 1 over.
By doing what?
By going for more than whatever runs.
Can you remember?
More than 15?
They said is that we will tell you exactly in which over.
Okay, so, yeah.
Alvaro to say, we're on our way to Durban. We want to obviously do something tomorrow.
Right.
Right. Obviously had a meeting with Lopsy
When?
and Tom at the hotel.
That night?
That night.
Yeah. And you went to the hotel. What was the plan?
The plan the next day was Lions bowled first. Okay? Is that? Huh?
No.
Lions bowled first. 10th over or the 20th over. Lopsy had to bowl. Okay? If 5 wickets or more down, then the bat was off. And if they bowl second, he had to bowl the 6th over. Because here you've got a captain on board, so you already guaranteed
A 6th away.
6th over 10th and the 20th. They were supposed to pick up money, deposit. Remember, Lopsy is an opening bowler. So if you bowl first, he's not going to, very seldom he comes and bowls a 10th or a 9th over. He doesn't. But he definitely bowls the 19th and the 20th. Then they would have told Lopsy, if you bowl in the 19th or the 20th over, then you're going to give a signal. If it's less than 5 wickets down, bat is on. And your signal can be, it could be 3 overs before that. You can change your wristband to a yeah.
When was it 100,000? When was that arranged? Was that previously arranged? They went there expecting to pick up 100,000?
No, they knew.
How did they know?
Because when we met in the Radisson, we said, you're going to come forward and say tomorrow's game, if you're going to do something, come and pick up 100,000 rand, just to have a surety.
All right.
So, but if you don't do it, you're going to pay that money back.
If they went through with it?
Yeah, and they'll get 600,000 after that.
Additional 6?
Additional 6. But on that day, the amount was changed. On that night when we had a meeting at the Hilton, obviously we expected Alvaro, Sanctions, Pumi, and Lopsy to play in the same game. Sanctions he played and he bowled the 9th over, Pumi bowled the 20th 10th over. Alviro did something in the batting, and Lopsy bowled the 20th over. That means the whole game is fixed. If there's 4 guys involved, who's going to go for 14 runs? It's already 4 overs, 60 runs already done. Done and dusted.
Yeah.
So the game is gone basically.
Yeah.
Then those guys bet on Lions to lose a game also. That's a different bet.
Right.
So then they said to Dami, look, we can't give you that amount. Because we can't, no, we can't give you $50,000.
Yes.
We have to negotiate a lesser amount.
Yeah.
Obviously, Dami said, look, no, I'm not interested. I'm the one who's in charge here, and I can bring him on whenever I want, etc. So what they said, each whatever it is.
And do you agree to that?
Yeah.
What is the financial arrangement?
No, they had to pick up $100,000 rands each.
Each, yeah.
He said, okay, we'll give you R1 million between the both of you, if you do something. I'm expecting somebody to bring some cash for me tomorrow. Okay? So tomorrow before the game, come and pick the cash up. After the game, come and pick up the rest. That game whom you investigating, that game endeavor, okay? There were 3 people who Vicky spoke to. Tommy, Lopsy, and Alviro. Okay? All 3 were supposed to do something. And then the game endeavor. He rang me on the morning of the game. He WhatsApped me. He said, my game be 11 o'clock. So he said, look, we're looking to do something in today's game. If you're keen, you can come and collect 100,000 rand today. And then once the thing is done, and after the game, you can collect the other 600. So Viro said, look, he doesn't really like talking about these things before the game. 2 o'clock or whatever. So I phoned him. I said, look, Alviro, have you thought of anything? He says, 300,000 up front, less later, yes or no?
Yeah.
So I spoke to Vicky. While he's on the phone, I said, look, Vic, he wants 300,000 up front. 100,000, he can give it to you right now. 600,000, give it to you later. Then he said, no. We leave it for other time. Call it. He said, no, call it off.
Peterson said no.
Peterson said no, call it off.
So, these were totally unrelated, these 2 approaches. That's what you're saying?
Yes. They're totally 2 different, not the same people.
Yeah.
So obviously, if Alviro does, that's it for instance. Yeah. If Alviro in the 9th or the 10th over scored less than 9 runs, he will get 240 from Manish, and 600 from, so 840,000 rand in total.
Okay. So as far as you're concerned, at that point the fix is on?
No, the game was on. It was on.
Yeah.
Right.
Okay.
You know, he met Tommy in the garage in Gateway.
Right.
Tommy came there, picked up the 200,000 rand. Lopsy wasn't there.
Right, so under the mythology of cricket.
Of cricket Canada.
Yeah.
Oh, we might have to reball that as well.
That is the best wide I've ever seen in my life.
A very good over for the Sunfeld Dolphins. 18 from it. It's 144 for 6.
Half in line se bowlers het deurgeloop.
Good start from Victorious and just fell to Kevin Peterson in the end.
Obviously, I was expecting Lopsy to come in the 20th over. He didn't. Vicky comes to the hotel.
You call him?
After the game.
You call him?
Yeah. He says, what? You know, he said, come on, just tell these guys to fucking give our deposit back because fucking tired of the shit. He says he's supposed to bring him on in the 20th over, he brought him on in the 19th over. And after the game, we went to the hotel.
To Gateway?
Met Tommy Tommy opened the door.
Image of the room.
Of the room.
You went up to the room.
Yeah.
Tommy's room?
I said to him, Mara, today was a perfect opportunity to do something. And he said, yeah, fuck, we missed the trick. We missed the trick today, fuck, we fucked it up badly.
Was Lopsy also
Lopsy was there.
And Vicky and yourself?
Yeah, 4 of us.
And they just handed the 100,000 back again?
Lopsy had the money in one of the car. I think it was one of his friend's car. He's giving back to Vicky. I said, after the game, I waited for Alviro. Alviro came to the car park and started discussing. And he asked that, did anything happen in today's game? So I told him, I said, yes, Lopsy was supposed to do something in the 20th over, but because they were 5 wickets down, nothing really happened. You understand? Tommy actually fucked the whole thing up.
I'm trying to figure out what was the point that made him decide.
I think 300,000 rand.
That was the thing.
Yeah, 300,000 rand. 300,000 rand. That was it. Maybe had Vicky given him 300,000 rand, he would have taken it with a smile. But if he was clever enough, he should have taken that 100,000 and come and give it to you straight away. I could give him this money. Let's put it this way. If he really wanted to report at that time, he should have went and taken that 100,000, okay, give me the 100,000, he doesn't have to do it. You have to, according to the code, you have to report straight away.
And as far as you're concerned, there was no fix that took place in that particular game?
Well, I can guarantee, I can put in here, said I've come forward here, there is absolutely nothing. You can bring out hawks, the works. No, I'm telling you now, as we sit, I'm giving you every single angle of everything what has happened. You called me in a day later, and then I told him it was under investigation, and we just left everything.
Mention again, like I said, this is inquisitorial. We're not trying to catch you out today. We're really seeking information. We've got duties to investigate and to explore evidence where it takes us, as you both know and been in these types of things before, I'm sure. So, if we've got a lot of questions, we want to let Tommy speak for himself. We're going to try and minimize the interruptions, but of course one question leads to another one. So if you think that any of our questions are unfair, step in. Feel free to clarify things and ask questions as well.
Previous night on the 3rd, when he said Kulam was coming, why would we go and see Kulam? And the game was televised. Why would we go and see Kulam in the morning of the day of the game? And then if you weren't interested, obviously you wouldn't have entertained it.
But did that not concern you as a captain?
I didn't bother, to be honest. I didn't bother.
We certainly don't have in terms of our emotional space. It's important to realize that there's no personal vendetta. This is not a personal issue. There's a number of players involved.
Yeah.
I don't care who they are.
Okay.
I don't do individually.
All right.
We've got to get to the bottom of it. We've got to protect the game. We've got to make sure it doesn't happen again.
Okay.
And really, those are the essence of the charges. And Ryan, your attorney, I'm very pleased that he came, because it's important that you've had that time to discuss the implication of this with him. And we just want to also, as we've discussed, it's being recorded now, and emphasize that you're coming here of your own volition.
Sure.
We've not pressurized you to come in any way or in any manner, and it's important that that's just recorded. And then it's important, as I said, that we go through the charge sheet. I'm very pleased to hear that you have had a chance to go through it and read it. Is that correct?
Most of it, the main things.
Yeah.
Let's just make sure that you understand exactly what it entails.
We're going to go through it again.
Okay, sure.
We're going to go through it again. It's
You have to
important.
understand.
And Mr. Hazard has also had a chance to read through it and talk to you about it. Is that correct?
Sure.
Yeah. So under the the charge sheet is really the start of this formal process under that corruption code.
Sure.
And the letter goes on to explain what the potential sanctions are, in other words, the penalties under that charge. And you will have seen that for the first and second charge, for each of those, the sanctions or the penalties are a minimum of 5 years, a maximum of a lifetime ban for each of those. This letter goes on to explain that, if the tribunal, if this goes to a hearing and the tribunal, who is an independent body of people, they're people who will be appointed to hear this. If they find that you've acted in bad faith, then they can order costs against you. They can order you to pay the cost of those hearings and the significance of that. And then the letter goes on to say that you need to respond by the 30th of December.
Sure.
And that if you wish to oppose the charges, then you'll ask for a hearing, and we will go to a hearing sometime in the new year before a panel. Usually it would be a panel of 3.
Mr. Ombudsman, a lot of this will become a lot clearer as we go through the chronology of events.
In fact, I think at some stage, it's just that I don't have the transcript with me here, there was a stage when the victims, so-called, were veered into match fixing. And though I allowed a period during which they sought to address match fixing, qua match fixing, as an issue, I indicated that we must always bear in mind what this inquiry is all about. I believe there is a time and a place when match fixing, qua match fixing, has either been dealt with by Cricket South Africa, or is being dealt with by Cricket South Africa, or will be dealt with by Cricket South Africa. And I'm very concerned that we may focus on match fixing, qua match fixing, without relating it to the terms of reference. The way I understand it, my mandate is to inquire into whether gender and race discrimination had an impact on the Office of the Transformation Ombudsman. That office was established and has been established, and it looks, in terms of its terms of reference, into incidences of racial discrimination, gender discrimination, and the extent to which they impact on the transformation of cricket. Now, that broadly is the parameters within which I act. I don't think it is in my province to deal with whether or not there's veracity that needs to be attributed to claims of match fixing, qua match fixing. My interest is to the extent that match fixing, if at all, had anything to do with the broad parameters of my mandate. Did it affect racial discrimination? Was it perceivably, whatever it was it perceivably something that impacted on the race of those who were either doing it or those against whom it was impacting? And of course, gender discrimination is also something that I must take into account. So, when we look at the objectives of the Office of the Ombudsman, it also wants me to determine the causes, the nature and the extent of racial discrimination and lack of transformation in cricket structures since unification. And then it tells me all the the perspectives that I must look into circumstances, factors, and context of such discrimination, as well as the perspectives of the victims and the motives and perspectives of the alleged perpetrators, and to conduct the investigation and holding of hearings and affording those who are named as perpetrators is intended to give them an opportunity to respond to these kinds of allegations against them. So, yeah, I mean, match fixing, for what it is worth, it must, in the end, be related to the extent to which it can be shown to have been a manifestation of either gender discrimination or racial discrimination, or both, in instances where a case can be made that it was violative of race discrimination and gender discrimination. Much else, in my view, belongs elsewhere. I've been looking at my terms of reference, and I've been looking at what it says here. I don't think we should spend any more effort without trying to relate it to the terms of reference. And I don't know if you have got any submissions to make in regard thereto.
Yeah, Mr. Chairman,
Both parties.
Can I just make the following submissions?
Yeah.
As I understand the allegations leveled by some of the players that were involved in match fixing, they suggested, number one, that Mr. Cole and Mr. Becker were racist and targeted them because they were black players. Now, if that is correct, that clearly falls within the terms of reference.
I agree.
Secondly, there's the suggestion that a white player in the form of Vaughan van Jaarsveld was not charged when he ought to have been charged. So again, there's the suggestion that a white person was given preferential treatment. And that would also be the subject matter within your terms of reference, because that would be a racist practice if you allowed the white guy to get away with it, but you implicated and you charged each of the black players that were involved in the match fixing investigation. Unfortunately, from the players that were charged, you ended up with 7 black players, and that including Elviro Peterson as black, Ghulam Bodhi as black, and 1 white player in Jean Symes. So that, on the face of it, does create the impression that something's wrong here. Why do you have 7 black players that are charged and only 1 white player that's charged? And I think because of that, Mr. Cole is keen to go through the chronology of the investigation in order to demonstrate where the information surfaced at the different points in time, in order to demonstrate to you that it was coincidental that you ended up with 7 black and 1 white that was charged, and it wasn't a case of white players being given preference and the black players being targeted. So it's unfortunate that those were the allegations that came out. And from Mr. Cole's perspective, I think he needs to tell you the story so that if he has, as he said earlier, acted in a racist fashion, you can recommend to CSA that he's racist and he ought to be dismissed. But similarly, if he convinces you that this was a thorough, proper investigation and he had sufficient information to charge the people, then hopefully that will be a conclusion in the report, so that this cloud that currently hangs over Mr. Cole's head doesn't continue hanging over his head.
No, it's just that I don't want this entire inquiry by me, in terms of my terms of reference, to degenerate, wrongful use of the word, to sink, same thing, to be focused on match fixing, unless and then, it can be shown that match fixing was a manifestation gender and racial discrimination to the extent.
Well, that's what I understood the allegations were, and my understanding is corroborated by the notice that was sent to me addressed to Mr. Cole. And that notice says the Ombudsman would like you to address the following issues in your response. 1, what was Vaughan van Jaarsveld's involvement, if any, in the alleged match fixing? And I'm not criticizing Worksman's or the office for raising that, because that was raised squarely by Mr. Peterson. He said, as far as he's concerned, Vaughan van Jaarsveld should have been charged, but because he was white, he wasn't charged.
Yeah, right.
Okay.
You see, that's that. You know, gender and race discrimination, if it can be shown to have impacted on what happened, is part of what I need to be investigated.
Then secondly, how different is Mr. van Jaarsveld's involvement, if any, from that of Messrs. Totsobi, Peterson and Mbalati?
Yes.
See what Mr. Mbalati says regarding van Jaarsveld at page 124 to 1298 of the transcript and paragraph 60 to 62 of Mr. Mbalati's affidavit. See also what Mr. Peterson says about Mr. van Jaarsveld at 1046 to 1048 of the transcript to his evidence. Then thirdly, Mr. Cole was asked to comment on, were those subjected to your investigation intimidated, coerced or threatened with criminal investigation should they not cooperate with your investigation, as testified by Messrs. Sotsobe at paragraphs 18 to 32 of his affidavit and Balati at paragraph 65 of his affidavit. Then 4.4 says, from the individuals who were under investigation, how many did you report to the South African Police Service and why? 4.5, how many players were the subject of your investigation and what was their race or demography? And then 6, it is alleged that there are white players who were also approached by Mr. Ghulam Bodi, attempting to persuade them to fix matches. However, these players did not entertain Bodi and neither did they report these advances. It is further alleged that despite being aware of the information, the investigators did not take any action against those players solely because they were white. Please shed some light and details of whether this is true. Again, going to this notion that there were people that were favored because they were white. 4.7 says, when were you first informed of the alleged attempts to fix matches and what did you do upon gaining that information? And this affidavit is deliberately designed to go into the chronology, because I think once we go through the chronology, the Ombudsman will get a much better appreciation for who were charged and why they were charged and who wasn't charged.
Mr. July, do you want to?
I share your sentiments. Having watched the video, I don't know how that video is going to help us.
I can't hear, sorry, sir.
I'm saying the video that I've watched, I'm not convinced that it is going to help with anything that has been said here. What is important from our perspective is Mr. van Jaarsveld and Alexander, what is his name? Craig are said to be whistleblowers, right? Now, then Alviro reports this issue on the 12th. In fact, on the 8th, not on the 12th. On the 12th is the meeting.
It's only a
report. Is told that you will come and meet with Mr. Cole on the 12th. He speaks to Mr. Tony Irish on the 8th, right?
Great.
He reports it almost 2 days or 3 days in the same way that Mr. van Jaarsveld did. Mr. van Jaarsveld got to know about this on Saturday, and he reported it on Monday. Now the question is, why is Alviro, now just giving an example, why is Alviro being treated differently from van Jaarsveld?
Mr. July, I'm afraid I don't think you've read the complete affidavit
Which
of
one?
Mr. Cole, because the affidavit makes it clear that, firstly, a report to SECA is not a report. And let me finish. I allowed you to talk. The report the report to SECA is not a report under the code, number one. But secondly, Mr. Peterson did not make full and frank disclosure. So over a period of time, he gave drips and drabs of information. He did not, on the first day, say he's been approached. He's been talking to Bodhi. All of that. He suggests on the first day it's Tsolakile. So he implicates on the first day Tsolakile, Tsotsobi, and I think it was Mr. Machikwa. And therefore, I think it is important for us to go through that chronology.
That's fine.
Once we go through that chronology, you will get a better sense of why Mr. Peterson ended up being. You'll see Mr. Peterson talks in October 2015. He meets with Mr. Cole and gives a statement in January 2016, which also doesn't constitute full and frank disclosure. There is then further information that emerges from Mr. Bodhi and from some of the other players. And during those interchanges with Mr. Bodhi, Mr. Cole discovers that on the 4th of November, which is the date that he told Mr. Cole that a fix was going to take place, earlier that day, he met with the bookmakers. The bookmakers offered him 100,000 rand. He said he wanted 300,000.
Are you testifying now?
No, it's not a question. I'm responding to your question.
Wait. You are taking this too far. I'm just making an example. I was just making an example. All these things that you're talking about, I've read, and stop making assumptions that I have not read the affidavit. I've read that affidavit thoroughly. But I was just making a distinction to say you go to another charge. I was just making an example by one charge, which is, what is a reasonable period in reporting? Felt got to know about, I hear you about these other charges. Felt got to know about this on a Saturday, he reports on a Monday. Alviro got to know, and also Felt reports to SECA, right? And we'll deal with the issue as to exactly which code are you guys talking about? Which code was applicable when all these things happened? You know, and these are the things that may not be answering the question that is before the Ombuds. The question before the Ombuds is whether other players were treated differently. I don't see the 23 players that are being told about there. Because as I understand from the affidavit, there were about 23 players, and 75% of those were black, and 25 of those were white, and only one white person who was. I'm raising this as a way of an example of how this thing comes to the attention of the Ombuds. So let's not make assumptions about the reading or not reading.
Gentlemen, let me address both of you and say that what is going to be guiding me are firstly the terms of reference. The terms of reference for this project, which Cricket South Africa adopted and eventually made available to us on the 1st of July 2021. I believe you have them. And it sets out in relevant part what the principles are that are guiding my appointment. And my appointment is stated there as having as its purpose contribution to truth, healing, and reconciliation in the game of cricket as part of Cricket South Africa's social justice and nation building project. Those are words. But then in paragraph 2, in further adumberation of the principles, it says in addition to adhering to the values of Cricket South Africa, which are contained in Schedule 4 to the Memorandum of Incorporation of Cricket South Africa, NPC, I ought to apply, or I will apply, principles in fulfilling my mandate in terms of the terms of reference. Accessibility, victim-centeredness, confidentiality, promotion of the health and safety of participants, representativity, transparency, accountability, and open and honorable process, comprehensiveness, inclusivity, an educational and holistic approach, justice, fairness, respect, voluntariness, and flexibility. And then it goes on to talk about reconciliation. And then it says, the Ombudsman shall be guided by the following principles in dealing with victims. And then it talks about, victims shall be treated equally without discrimination of any kind, including race, color, gender, and all of those things. And then it talks about procedures for dealing with submission by victims shall be expeditious, shall be fair, inexpensive, and accessible, and appropriate measures shall be taken in order to minimize the inconvenience to victims and when necessary to protect their privacy and protect them from intimidation. Then it sets out what my objectives are. To promote equality in cricket, but in relevant part it says, I must determine the causes, nature, and extent of racial discrimination and lack of transformation in cricket structures since unification. And I should include the antecedents, circumstances, factors, and context of such discrimination, as well as the perspectives of the victims and the motives and perspectives of the alleged perpetrators by conducting investigations and holding hearings and affording the alleged perpetrators the opportunity to respond to allegations leveled against them. I must establish and make known the fate or whereabouts of victims, but most importantly, it says I must compile a comprehensive report to the board for its consideration on the activities and findings of the Ombudsman, and which contains recommendations of measures to prevent future incidences of racial and other forms of discrimination in cricket. So I think we must bear in mind all the time that in the end, I must be comfortable with where the evidence is leading us and whether the evidence is a manifestation of race and gender discrimination in the office, and that the office of the Transformation Ombudsman is charged, especially in these hearings, with bringing out the extent to which anything that was done by anyone was a violation of racial and gender discrimination. I mean, a violation of parity of the genders and races. So it's a broad mandate that I've been given. But at the same time, we should never lose sight of the fact that the inquiry is into race and gender discrimination to the extent that that exists, and whether that was the basis to lack of transformation as we understand transformation in cricket structures since unification. So I thought I must bring to the attention of the parties that we should not veer very much away from the terms of reference of this project, the social justice and nation building project.
Mr. Ombud, may I make a comment, please?
Yes.
Thank you very much. Mr. Ombud, the match fixing saga was not raised by us. We in fact said that it is not within the mandate of the Ombud to deal with this. It was
By us, you mean who?
Sorry?
When you say it was not raised by us,
we did not raise the issue of match fixing and the allegations that had been made. The players came before the SJN and they made certain allegations in which they clearly indicate that I conducted a racial or an investigation based on race. The Ombud accepted all of their versions. I did not come here today because I want to be here. I was invited by the Ombud to come and answer to certain allegations, which Mr. Musaji enunciated. All of the other participants in these hearings have been given a full and a fair opportunity to state their case, to enable the Ombud to make a finding at the end based on evidence. The evidence, or the allegations, as I alluded to earlier, was specifically that we had no evidence to charge these persons, but that I targeted them not because they're white, but because they are black. And I am sitting with this cloud over my head that I'm a racist. And in as much as there is no place for racism in our society, there is no place in society for somebody to use the race card to target.
Yeah, well, the evidence that comes from you must be such that
Absolutely.
I am aware that you are responding to the extent to which whatever was happening, match fixing or otherwise, was racially based and gender based, and it was unfair on that basis. I'm not interested, I have to say this, and this is a prima facie, I'm not interested in the details of how match fixing, how was it done, and was it. If, however, it answers my mandate, and my mandate is to find out whether there was race or gender discrimination of any sort, discrimination which was unfair, that whatever activity was going on, then to that extent it is relevant. I only hope both all the parties understand that I don't want to muzzle anyone. I mean, this is an informal process, as processes can be informal. I even allow hearsay evidence because I'm inquiring into exactly what happened. But we should never veer away from the primary objective. I don't want to hear match fixing for its own sake. I want to be able to say this evidence on match fixing falls within the parameters of my terms of reference, falls within the parameters of what my inquiry is about. My inquiry is about the extent to which there was an impact on the cricketing code, on the sporting code called cricket, by racial discrimination, which must have been unfair, and by gender discrimination, which must have been unfair. If whatever anyone says, they are able to bring whatever their testimony is intended to be within those parameters, then I'm happy. But I don't want to spend hours and hours on end getting details about people meeting in dark corners and what have you, if it is not going to be promotive of my major objectives. And I don't know whether any of the parties want to respond to that.
I think we must go on because the purpose of the evidence is in order to demonstrate that there was no racism involved, there was proper evidence on which the charges were pursued, and that will take you through so that everybody gets a good understanding of why who was charged were charged and who wasn't charged weren't charged.
And how race and gender did not form part of it.
Absolutely.
Mr. Musaji, if I may ask, are you able to give evidence in such a way that doesn't necessarily go into the, as the chair states, it doesn't necessarily go into the, details of how the match fixing took place, but directly answers or speaks to the mandate of the Ombuds.
You will see when I ask the questions that I'm focusing on the critical dates when certain information was shared, and hopefully demonstrate through that. And I think if I count, there's about 14 independent sources of information that inform who was charged ultimately.
Okay, no problem, thanks.
All right.
And race and gender was?
Well, the difficulty, Mr. Ombud, is that 7 out of the 8 players that were charged were black. And the players that came here, that were implicated in match fixing and signed sanction agreements, where they pleaded guilty and accepted bans, those very same players were sitting here in the witness box suggesting that they were discriminated against simply because they were black. And if one goes through the chronology, it becomes evidently very clear that there's no merit to any suggestion that those players were targeted because they were black. Mr. Go, let's try to keep...
Can we have, what time are we at now? Can we have a 5 minutes?
Sure.
Body break. Yes, Mr. Musashi.
Thank you. Mr. Cole, in paragraph 21 of your affidavit, you deal with how many players were initially the subject of the investigation. Please just tell us.
Is it paragraph?
21.
Okay. Okay.
Sorry.
Yes.
Mr. Ahmed, during the course of the investigation, I investigated, apart from the 7 players that had been charged and banned, another 23 names came up. And they came up in the sense that they were mentioned firstly by Mr. Peterson, where in that meeting of the 12th, he mentioned many players. Those names came up as a result of a misunderstanding from their side about a meeting that had taken place, which they thought was match fixing. But I had to go through, as an investigator, I had to still follow up on those. So in total, there were about 23. Of those, about 75% were black. I then further uncovered about 8 players, all of whom were black. That
when you say black, you mean black in the broad sense?
In the broad sense, if you can guide me what the correct term is, I feel uncomfortable to say that. I'd be happy. Players of color.
It's African colored and Indian.
Sorry? Oh, African colored and Indian, yes.
Yes.
I'll have to think about the composition, but I think they were predominantly, and they were international players from other countries that was mentioned. I had to go into each of them to decide whether they were in any way involved. Mr. Bodie also would mention names just to play, when he recruited them, to put players at ease, to say that these players are involved, therefore you don't have to worry. I had to go into those as well. So of all of them, there were about 8 other players that I could have charged under the code, but would not advance the investigation. It was, for example, where further predominantly in January of the next year, where it became to surface in the media of what players were involved. They would then phone people who were participants under the code and tell them about that. In terms of the code, they would have to report that to me. They did not do that, and we considered that with Judge Ngwepe, with ICC Legal, and also Mr. Arun Logat, who was the CEO at the time. So in total, there were about 30 players that we investigated. We considered their positions and decided not to charge them.
Yes.
In paragraph 22, you then talk of 2 whistleblowers.
Yeah.
Can you take us through that, please?
Mr. Von van Jaarsveld came forward and he said that he had been approached on the 12th of September during the Africa Cup, and also on the same day, I think Mr. van Jaarsveld was first. Thereafter, Mr. Craig Alexander, who was a coloured player, was also approached, exactly the same modus operandi at the same venue. Exactly the same figures were mentioned. I obtained 2 statements, sworn statements from each of them at a later stage during the investigation. And the evidence that they gave me was corroborated by an information note that I'd received from the ICC. So technically, they were considered as witnesses in our case. They made full disclosures, late as though they might have been. The first case of Mr. van Jaarsveld, if I can just answer Mr. July's question. In terms of the code, a late report can be considered by each case has to be considered on its own merits. In other words, one takes into account the late report of Mr. van Jaarsveld and Mr. Alexander. Was that in the information that they shared, was that in terms of the competition that they were playing in? That was the Africa Cup at the time. The arrangement was for them to participate 2 months later in the Ram Slam competition. That is one of the factors that one takes into account to say what is unnecessary delay. It could be, and it will become evident later when I talk about the timing of Mr. Peterson's report to me and what led to that. So they did not take money. They did not meet with the bookmakers. They declined immediately. They reported to SACA. Well, let me say Mr. van Jaarsveld reported to SACA. 2 days later, SACA phoned me and I said it only constitutes a report in terms of the code once it is reported to me. It specifically says that it has to be reported to me. The fact that they reported it, there was a custom at that stage, because I'd only started at anti-corruption and we were starting with the code, that in the absence of an anti-corruption officer to report it to, they would then report it to SACA or the agents who would then put it through to the authorities. I then said to SACA, it just does not constitute a report. It has to be reported to me in terms of the provisions of the code. So that was the difference between, or the question of their approaches that they'd reported to me.
So as I understand it then, just to clarify, you say Mr. van Jaarsveld and Mr. Alexandra reported, albeit maybe a bit late. Mr. Peterson also reported, albeit late, but as will become evident later, there were other things that were relevant to Mr. Peterson. What were those other things?
May I just add before we go there, so Craig Alexander did not report immediately. Everybody knew, as Mr. Bodie says in the video clip, that everybody knew about everybody's involvement. Everybody knew, Mr. Peterson included, that Mr. van Jaarsveld only reported 2 months later. Not 2 days, 2 months later. We did not charge him for that because we considered him to be a witness in the case that would advance the investigation. We discussed his, Mr. van Jaarsveld's, and Mr. Peterson's late reports. And when somebody purports to be a whistleblower, but he has separate meetings with them, if I can mention to the Ombud that for an investigator, a whistleblower is like gold dust. It's somebody inside of the investigation who tells you exactly what is happening. Mr. Peterson selectively told me. And do I need to go into the details?
We'll get there.
Okay, So he did not tell me everything. So we considered that. And then his motive behind not telling me was the determining factor as to why we charged him and not the others for non-reporting. That is basically the principle.
In paragraphs 23 and 24, you deal with what initiated the need for the investigation. Just very quickly, in a few words, what initiated the investigation?
Mr. Ahmed, we have an annual conference where all home boards across the world meet, and at the end of that meeting, I think it was September, on the 11th of September, the ICC gave me an information note to say that they had interviewed Mr. Manish Jain, who was the bookmaker that we had on the clip. They had interviewed him for his involvement in a matchmaking scheme with a Sri Lankan guy. And he said that Bodie had met with him and that they discussed in broad terms that they were going to try and fix the Grand Slam competition.
Okay, then in paragraphs 26 to 31, you explain the process of the investigation. Can you take us through that, please?
Mr. Ahmed, what I did as the investigator, I recorded each and every interview, both by audio and by video, as the video is just an example of that. I also automatically recorded I had an app on my phone, all telephone calls that were made. What I then did is I sent those recordings to the ICC, who assisted us with the transcriptions. They sent it to transcribers, who then sent it back to us, and then we worked on that. We made those available to the attorneys of the respective players. And what we also did then, and the code allows for that, is for us to get access to the phones. We sent it to a digital company, Cianre, and they downloaded all of the phones, which enabled us to, with the data that was extracted, to compile a timeline chronologically of each and every WhatsApp message that had been between the lot of them. The bookmakers, we also got that from Bodie's phone, his interactions with the bookmakers, with each of the other players. What subsequently to that happened is the minute I asked for their phones, Mr. Symes lost one and he had one stolen. Mr. Tulekile lost his phone whilst he was on the way in a combi, and a team combi bus, and he came back in a taxi. He said he left it in the taxi. Mr. Tsotsobe had his stuff deleted, so we had a lot of obstruction from the various players for me to get access. But as it is with a communication, it's a two-way thing, and we got most of the information, and the company was able to retrieve deleted messages that they had deleted on the date that I on a material significant date.
Okay. In paragraphs 34 and 35, you give more details now about the players that were ultimately charged and the various interviews you had with them. Please take us through that.
What we did, as can be seen in the video, is that we had interviews, formal interviews, such as this with each and every player. Our process basically was to follow the evidence, and if Mr. Bodie said that he had approached Peterson and Tami, for example, Mr. Tsolekile, I would then go from the one to the next. We would then set up meetings. My initial meeting was to just interview them because I did not know what their involvement was. Then I went through the process to give them letters of demand and ask for statements. We did that, and even though the Anti-Corruption Code does not specifically make provision for legal representation, Mr. Beck and I felt that the consequences were so dire that it was just fair to involve them. We allowed them to participate in an investigation. The role of the lawyer would be to make sure that we stick to procedure, that we don't threaten or coerce them, but we allowed them to interact with us all along.
All right. In paragraph 36, you outline the CSA official that you were regularly reporting to. Who was that?
In terms of my mandate, I report to the CEO, who was Mr. Logat at the time, and I kept him abreast of what had happened, and we had a structure. The head of the anti-corruption, independent head of the anti-corruption unit, who was Mr. Judge Ngwepe. And our process...
When was the judge appointed?
I think it was the 16th of March of 2016, I think. Yeah.
That's correct. Okay, then in paragraph 40 and 40...
Sorry to interject. Mr. Cole, who was the anti-corruption officer before your appointment in
There wasn't
2015?
one. I was employed to establish the anti-corruption unit, and I was the first one for CSA. And until now, I'm still the one.
Okay, thank you.
In paragraph 40 and 41, you set out your interactions with law enforcement authorities, and you also give details of a criminal matter. I raised this with you because there was a suggestion that you had intimidated, coerced, and threatened players.
Mr. Ahmed, the anti-corruption code that we charge them under makes provision for us to share all information that we gather in the course of our investigation with law enforcement agencies. I did that at a very early age. If my memory serves me correct, on the 26th of September of that year, and that's 2 weeks after Mr. Peterson had reported it to me first. I went to the police and they said to me, because I needed access to trail records of Mr. Bodie to check whether he had gone to India, etc. They basically said to me that I had to get more information because before they could formally engage with me. And then I think on the 27th of October, we opened a formal inquiry where an investigator was assigned to the case, and I then worked closely together with him.
Okay, then in paragraph 46 of your affidavit, 46 to 49, you deal with the very first report you received. Take us through that, please.
Yeah. Mr. Breetske, who worked for SACA at the time, he contacted me on the 14th of September, and he advised me that Mr. van Jaarsveld had reported to him that he had been approached by Mr. Bodie.
Go ahead. I'm sorry.
No problem. Must I continue?
Yes.
Oh, sorry. I then specifically advised Mr. Breetske, as I alluded to earlier, that in terms of the code, I knew that there was a practice that they reported to the agent or to SACA in the absence of an anti-corruption officer. Said to him it will only constitute a report once he reported to me directly. That same evening, Mr. van Jaarsveld reported to me, and what he had done, he'd given a redacted report to Mr. Breetske of what the approach was about. I then said to Mr. Breetske, I need the full report, and I also requested him to give me an affidavit because he was just an extra link in the chain. I received an affidavit from him and Mr. Irish with regard to the approach of Mr. Peterson.
Okay, and then in paragraph 48, you deal with a meeting you had on the 17th of September. Who did you meet with?
I then made an appointment with Mr. van Jaarsveld, and I went to go and see him at his home in Durban. And he basically said to me what had happened, what the approach was, and I also said to him I needed the full report of what had happened, not the redacted one. I got that, and I also said to him I will contact SACA, because at that stage it was just what he'd said to me. It was not a fact. I didn't know whether he was telling me the truth or not, and I said to him, go to SACA, they will appoint or assist you to get a lawyer, and once you have a lawyer, I want them to draft an affidavit for me, which they did, and I received that at a later date.
You then deal in paragraph 47 with you interacting with SAPS. Tell us about that, please.
47?
Sorry, 49.
As I said, on the 27th, I went to SAPS and they said that I needed to do more work, which I then did, and I then formally engaged with them on the 27th of October.
Okay. Then tell us what transpires on the 8th of October 2015. You deal with that in paragraph 50 of your affidavit.
At that point, I had the information note from the ICC. I had a report from Mr. van Jaarsveld, and then Mr. Irish contacted me. He was also from SACA, and he said he had another player that had come forward and said that he had information with regard to the match fixing thing. I then relayed to him exactly the same thing. It doesn't constitute a report. He has to come to me personally. And then Mr. Irish then phoned me again and said that they were coming up to Johannesburg and would I be available. And after a while they called me, I went up, and then I had a meeting with Mr. Peterson.
Okay, so on the 8th you don't get a call from Mr. Peterson?
No, not at all.
And you then meet with Mr. Irish and Mr. Peterson. When was that?
It was on the 12th of October.
And what transpired at that meeting?
Mr. Peterson told me that Mr. Tsolikile, had told him at a meeting that he had been approached, Mr. Tsolikile had been approached by Indians, which they call the big guys, and that he had been paid 75,000 Rand to get involved in match fixing. So essentially he was relaying information that Mr. Peterson had told him. He then went further.
Sorry, you said he was relaying information Mr. Peterson told him?
No, sorry, that Mr. Tsolikile told him.
Okay.
I apologize, that of what I had just described. He then went further to say that he gave me a diagram, and that is where the bulk of those players that had been implicated, of the 23 additional ones, had been mentioned by Mr. Peterson. He gave me a diagram of who he thought was involved in this thing, but that was based on an erroneous assumption, based on a meeting that they had on the 7th, a call that Tami Tsolikile and Elvira Peterson had, and they thought that it related to a meeting, a business opportunity. And because they had met on the 5th, they actually say that in the WhatsApps. It is what we spoke about at Nando's, and they spoke about the match fixing thing at Nando's. So they implicated a whole range of players, which I had to investigate. And then he went on to specifically mention which players were involved. He said Mr. Pumi Machikwe, Mr. Tsolikile, Mr. Symes, and Mr. Tsotsobi were involved. He mentioned them to me. I didn't target them. He said, these are the guys that you have to investigate. And then he said this recruitment strategy, apparently, according to Mr. Tsolikile, was to target captains and bowlers, essentially.
Sorry, again, you're saying according to Mr. Tsolikile.
Sorry, just repeat my...
You just said now, according to Mr. Tsolikile, they had to recruit captains and bowlers.
I apologize, Mr. Peterson. My mind is ahead of my tongue. Sorry, Mr. Ombudsman.
So can I just then recap? There's now 3 sources of information. You've got the ICC, you've got information from Vaughan van Jaarsveld, and you've got information from Mr. Peterson. And that information implicates Mr. Bodie, implicates Mr. Tsolekile, Mr. Machikwa, Mr. Symes, and Mr. Tsotsobi.
Not really Mr. Bodie, because crucially at that meeting, and Mr. Peterson had met with Mr. Bodie 2 days earlier on the 10th, where they discussed match fixing. But he does not mention that to me at that meeting of the 12th, when he discloses this corruption on an industrial scale in his words. He doesn't say that he met with him and they discussed match fixing. The only thing he says, he ran him out in a match two years prior to that.
Okay. As I understand it, Mr. Irish said to Mr. Peterson that he should give you more detail about Mr. Bodie.
Yes.
And what did he tell you?
He basically just said, tell us what happened with Mr. Bodie. As I said, he didn't tell me about their meetings prior to that. He said he ran me out in a match 2 years prior in the Champions League, which was not even close to what the truth was. It was a negligible incident that had nothing to do with the match-fixing allegations that they had been making.
Okay. The next development is a development on the 3rd of November 2015, which you deal with in paragraph 55. You don't need to give us the full details, just briefly what of moment happened on the 3rd of November 2015.
Mr. Bodie was on the way from Johannesburg to attend that particular match on the 4th, and he had with him, I think, two of the match fixers. Remember, there were two groups, and this is not the person that appeared in the video, it was the other group headed by Vicky. And in the car, they exchanged WhatsApps, which I also picked up on the forensic downloads, where they arranged for a meeting that evening to discuss the match fixing.
That's the evening of the 3rd
of November. Of November, yes.
Okay, and you then, on the 4th of November, there's another meeting that you refer to. You weren't party to that meeting, but you hear about this meeting much later. Could you just tell us what happened at that meeting?
On the morning of the 4th, at 11:30, Mr. Peterson phones Mr. Bodie and he says to him, we must meet. They then go to a meeting at the Mug and Bean close to the Gateway Centre, and they meet with the other Sidibukis headed by Vicky. It is him and, I think, Vicky and 3 others. And at that meeting, they then discuss what needed to be done in the match of that evening that started at 6 o'clock.
I'm not, again, going to go into the details just for the sake of time, but in paragraph 59, you make the point that you hear this from Mr. Peterson when? For the first time.
Mr. Peterson has and this is where the relevance of an immediate report becomes important. The meeting was at 11:30 and the match was at 6 o'clock that evening. The same match or the same the information related to the same competition that was going to be played that evening. There was about 4 hours that Mr. Peterson was obliged to tell me, even the previous day when they arranged this meeting. He only says in a WhatsApp he saw Mr. Bodie and friends. He doesn't say that he met with Mr. Bodie and friends and discussed match fixing the previous day. And at that meeting, the same thing. He doesn't say anything about that. Half an hour before the match starts, he calls me. All the telephones, which is part of my job, had been handed in, and he says, I need to tell you, he calls me to the balcony, I need to tell you about what is going to happen in this meeting. He says he walked behind Mr. Tsotsobi and Tsolekile, and he overheard them in isiXhosa talking about what was going to happen. He relays in detail what was going to happen that evening. But when we pushed him, he said that he didn't understand isiXhosa.
Just tell me the significance of this thing about telephones. That
is part of the protocols that we put in place, the minimum standards for players and match official areas, that before they go into the change rooms, they have to hand in all their phones to prevent them getting approaches or them giving inside information to bookmakers on the outside. So I take in all the phones and it's kept safely until the last match is played, after which they get their phones.
Yes.
Then in paragraphs 66 to 69, you deal with your first meeting with Mr. Bodie. Tell us how that came about.
I struggled for a long time to get hold of Mr. Bodie, and then Mr. Arun Logard arranged for me to meet him at these offices, or the previous offices at the Wanderers on the 6th of November, the morning. I then met him and said to him, the information that I have is that you're involved in match fixing. Here is a pro forma that I'm giving you. We call it a letter of demand, which says that I demand within 14 days he has to give me cell phone records or whichever information is that I need. I gave that to him, and directly after interviews later, he says to us that he had phoned each and every player to say, listen, Louis is investigating this. You must give the following version, or a concocted version of what actually transpired.
Okay. You then have another meeting in the afternoon of the 6th of November, which you give details of in paragraph 70 and 71. Can you take us through that, please?
It was a busy day, Mr. Ombud, because in the morning I went to see the police and the NPA. I directly left for the offices, saw Mr. Bodie, and after that I drove through to go to Potchefstroom, where a match was being played. And then I attended the match on that evening as well.
Okay,
excuse me, I apologize. Then before the match, I also then had a meeting with Mr. Peterson as my whistleblower to clarify certain things that he told us before. He changed the figure, which he initially said was 70,000, and changed it to 75.
Okay. So this is your second meeting with Mr. Peterson?
Yes, that was.
Does he, at this meeting, disclose to you that he had met with Mr. Bodie?
Not at all, sir, no.
Okay. All right. You then have a meeting on the 1st of December 2015. Who did you meet with? You deal with that in paragraph 72 of your affidavit.
I then went to meet with Mr. Peterson and his lawyer at his lawyer's offices in Midrand. And I then said that I would need a witness statement from him, and then I emphasized to him that he must include every detail, he must use his WhatsApps to corroborate everything. And I also at that stage mentioned to him that it is very important, because one doesn't want a situation to arise where the police ask him about certain things and it is not factually correct and not supported by evidence.
So this is Mr. Peterson's third opportunity
Correct,
to
sir.
disclose information to you, and he doesn't do so.
That is correct, yes.
Okay. Then in paragraph 73 and 74, you give details of another meeting that you held on the 2nd of December 2015. Can you take us through that, please?
Yes, I then met with Mr. Bodie and his lawyer, who was Mr. Ryan Hazrod, and together with two of my colleagues, or Mr. Becker and one of my colleagues at the Protea Wanderers Hotel. I basically informed him that we were investigating this and that there were allegations made by Mr. Alexander and by Mr. van Jaarsveld. He basically just denied. He said that he refutes any allegations made by these players. We then set up another meeting later.
Okay, in 75 and 76 of your affidavit, you give details of yet another meeting you had in December with Mr. Bodie. When was that?
It was on the 15th of December. I met with Mr. Bodie at the Magembeen in the West Rand. I then handed him a formal notice of charge, which basically set out the charges that we felt he was going to be held accountable to. He basically, I spoke to him and also mentioned to him that the Hawks was investigating that. I said to him that we needed to clarify because we had evidence to the contrary. And then he said to me he wanted to come clean, and we set up another meeting for the 21st of December.
What transpired at the meeting of the 21st?
Again, met with him with Mr. Ezrat, and he then said to us he wanted to make a full disclosure. I basically established that he hadn't been truthful because he incrementally told us what he thought we wanted to know. But at this meeting, however, he admitted guilt to, or admitted that the allegations that had been made by Mr. van Jaarsveld and Mr. Alexander was the truth. And then he also then said to me that he, what's the word I'm looking for, implicated Mr. Peterson, Tutsobi, Tolekile, Malati, Symes, and Machikwe.
So you now have 4 independent sources, and I'm not going to take you through all of them, but if you can keep count with me, and hopefully Helena and Mr. July will help us keep count. But now that's the fourth independent piece of information you have to charge the implicated players.
Correct.
But it's the first time that you've got information implicating Mr. Peterson.
Yes, that's the first time.
Okay. You then have a meeting on the 23rd of December 2015 in Centurion. Who did you meet and what transpired?
As part of my process of following the evidence, Mr. Mbalati was the first person that I approached. As I say, it was just mentioned by Peterson and Mr. Bodie that they were involved, and I said to them that I'm investigating this case. They've been implicated by other players. I need a version from him. Gave him a letter of demand as well, and basically said to me that he was not involved, and that Mr. Bodie had approached him at Nando's, I think it was, and he had declined the approach.
Okay, then in paragraph 81...
Was that on the 23rd or the 24th?
23rd. So that it starts on paragraph 78. That was on the 23rd of December.
I'm running ahead of myself. I was 81.
Okay. All right, we're getting to 81 now, Mr. Chair. So on the 24th of December, you had another meeting and you give details in paragraph 81 of your affidavit. Who did you deal with?
Exactly the same process. The evidence led to Mr. Machikwe, and I set up a meeting for him at the Protea One, at the Wanderers Club. And he gave me exactly the same story, that Mr. Bodie had approached him, that he had declined, and I handed him a demand letter and said that I would be requesting certain information by a certain date from him.
Okay. You then, there are developments on the 24th and the 28th of December 2015, which you outline in paragraph 82 of your affidavit. Please take us through that.
After deliberations with the ICC, with Mr. Logat and Mr. Becker and myself, we decided that we had enough evidence to charge Mr. Bodie, and then based the first notice of charge we served on him on the 24th related to information coming from Mr. Alexander and Mr. van Jaarsveld, and then we amended the charge sheet on the 28th, which included the approaches to all the other players that had been involved, and it was then served, I think, on the 31st, if I'm not mistaken.
I think on the 31st, you end up concluding an agreement with Mr. Bodie.
Correct, yes.
Tell us about that agreement, please.
Mr. Bodie was then confronted with all of this. He decided to plead guilty, and we said that he pleaded guilty to 22 charges that we had put to him, and he was then banned for a period of 20 years, of which 5 years was suspended, and he got 15 years effectively.
Were there any criminal charges laid against Mr. Bodie?
By that time, I had already approached the police, and I had opened an inquiry on the 27th, did I say, of October. So a case had been opened by that stage, yes.
Was Mr. Bodie charged eventually?
Well, eventually he was charged, but at that stage it was still being investigated by the Hawks.
But do you know what happened to those charges?
It is still current, and he was found guilty in the Commercial Crimes Court in Pretoria and sentenced to 5 years imprisonment.
Okay, then in paragraph 85, you deal with a meeting you had on the 5th of January. Who did you meet with and what transpired at that meeting?
At the same time in December, I contacted Symes. He said that he was on holiday, and then I made an arrangement to meet him on the 5th of January. He admitted that Mr. Bodie had invited him to a meeting. He said that Mr. Bodie had mentioned numbers. He didn't really consider that to be an approach, but he conceded that he should have taken it more seriously, and I then went through the same process with him, said, here's a letter of demand. You have to give me certain information, his telephone records by a certain date.
Then in paragraphs 86 and 87, you deal with your attempts to meet with Mr. Tsolekile.
Mr. Tsolekile, I was down in Cape Town and I tried to get hold of him. He basically said he was not going to meet with me. He was not going to accept a letter of demand. I then informed him that that would just be an additional charge if he refused to cooperate in terms of the code. And I then asked Mr. Becker, who worked in Cape Town at the time, to go and serve a letter of demand on him at his home.
Okay. Then there's a development which you describe in paragraph 88 of your affidavit. Please take us through that.
Based on my previous meeting at Mr. Twaddle's office, we had asked him for a statement. They provided
When
me...
you say him for a statement?
Mr. Peterson for a statement. They then provided me with a statement on the 18th of January, which was sent via email by Mr. Twaddle.
So it's a statement from Mr. Peterson, but sent to you by his attorney, Mr. Twaddle.
Correct, sir.
Okay, and what's of moment in that statement?
There was significant new information in this in this statement that he had not previously divulged to me, in which, as my whistleblower, he was clearly obligated to do that. And in this affidavit, he then admitted, he put it into his statement that he had met with Mr. Bodie at the Wanderers Club on the 10th of October. That was 2 days before he reported it to me, where they discussed an investment into his cricket academy, which, as you heard on the video, Mr. Manish Jain, the bookmaker, said it was just for the show. It was a code word which Mr. Bodie and Mr. Peterson later said they used code when they referred to the match-fixing scheme. He said that they also met with another set of bookies late of October at Melrose Arch, where these other bookmakers also wanted to make an investment into his cricket academy. And he then said that he met with 2 other Indian males on the 4th of November at the Mug and Bean, and where they had offered, also wanted to invest in his cricket academy.
But does he tell you that this cricket academy was code for match fixing?
Not initially, but when we saw him in Manchester later...
No, we'll get to Manchester.
Okay.
I'm talking of it this stage.
He does not say that to me.
He doesn't, okay. All right. So he's now had 5 opportunities to come clean with you.
Correct,
There's been
sir.
various meetings, plus there's the statement, and he still hasn't made full and frank
That is
disclosure.
correct, sir.
Okay. Then in paragraph 90, you deal with a meeting you had on the 20th of January. That was a meeting with?
Also, again, Mr. Bodie and Mr. Hazrat, his legal representative, where he gave us additional information as the investigation progressed.
When was your next meeting then?
It was the next day, on the 21st of January.
Who did you meet with?
I met with Mr. Tsotobi, and that is the meeting that we saw in the video, where he was really not being truthful. He was very incoherent, where he said he knew what match fixing was, and he didn't know that Mr. Bodie was involved in match fixing. He basically was not being truthful to us. He mentioned the figures, said that what he had to do, the proposal by Mr. Bodie, to concede 14 runs or more, and that for that he could earn 700,000. He said he didn't take him seriously. He thought that Mr. Bodie was a joker, and later then also conceded that he should have taken it seriously and reported to me.
Right. Then we go to paragraph 96, where you describe another meeting. Is the date in that paragraph correct?
Let me just get there, sir. No. The meeting with Mr. Tsolikili was on the 22nd of January. I apologize for that in my statement. Was the 22nd of January. And
well, I mean, you say on or about.
Yeah, it was in fact it was the 22nd. I met with Mr. Tsolikili, and he was in the presence of his lawyers, Mr. Lourens van Sail, Mr. Francois Brink, and
we also saw snippets of that meeting.
Yes, we did, yes,
in the video.
And Mr. Ines Ferreira, who was an advocate. One of them represented his Mr. Tsolikili's agent. I cannot say which one is Mr. Becker. I'm sure would allude to that.
Okay, and what transpired at the meeting with Mr. Tsolikili?
Basically, we informed them we had a set, not strategy, but way that we dealt with it. We said to them that we're investigating this matter, and it was in terms of the code that the matter had been reported to the police, and that evidence that we collected in the course of this investigation would be shared with the police. I also advised him that the meeting was recorded, and that neither of them objected to that.
So this is now the 5th piece of information that you have in order to charge the implicated players.
Correct, sir.
Okay. And it implicates Mr. Peterson as well?
It does.
Okay. Then on the 25th of January 2016.
Which paragraph, sir?
Paragraph 100, you set out another development in your investigation. Please take us through that.
Let me just get to that if you don't mind. Oh, there we go. Then on the 25th of January, I forwarded by email a letter of demand, as I did with the others, to Mr. Tsotsobi requesting him that I needed certain information.
Okay. Then in paragraphs 101 to 104, you set out information that you managed to obtain from a hotel in Sandton. Please take us through that.
In the course of the investigation, I established that the one set of bookies had come to South Africa between the 20th and the 24th of September, and the other set of bookies on the 25th to the 31st of October, where they met with various players. And I then, to establish whether that was true, I went to the Radisson Blue Hotel that they had met and paid all of these players. And he basically said that he gave me two names, initially very guarded. Gave me two names of two of the bookmakers, which enabled me to establish that who they were, and that it set in motion a procedure where we were able to follow up more of that information.
Then in paragraph 105, on the 10th of February 2016, you deliver a letter of demand to Mr. Peterson. Now, bearing in mind that at that stage, you deemed him to be one of your whistleblowers. Why do you deliver a letter of demand to him?
I then became very suspicious with regard to the versions that he told us and with the evidence that we had collected and the revelations by all of the other players. And then I said, here's a letter of demand. I need to verify some of the version that you've given us so that I can establish what his position was.
Why do you then meet Mr. Lee on the 11th of February 2016? You deal with that in paragraphs 106 and 107.
Can I just mention that Mr. Lee was interviewed by me purely as a witness, and I know that I'd spoken to him afterwards. He felt very bad about that, but he just enabled me to verify the version that Mr. Peterson had given me, where he heard the details of that fix. Mr. Peterson's version was that he walked behind him in the lobby, but Mr. Lee then confirmed to me that Mr. Peterson's story was not, and Mr. Tsotsobi, he said that he walked down the lift with Mr. Tsotsobi. Tsotsobi went down to the basement to his car, drove around and saw Mr. Peterson in his car in front of it, and Mr. Lee confirmed that it was not a full and frank disclosure.
So now you've got the sixth set of information about Mr. Peterson telling you that he wasn't being entirely frank and honest with you.
That's correct, sir.
Okay. Then in paragraphs 108 and 109, you talk of discussions you had with Mr. Pangiso on the 11th of February 2016. Why do you check to him?
Exactly the same. I need to say that he was a witness. He was not implicated in any way. I needed to corroborate the story of whether Mr. Bodie was there and whether Mr. Peterson had actually walked behind him, and he said that he did not know if Mr. Tsotsobi had met with Mr. Bodie on that day.
Okay. You then in paragraphs 110 and 111 give details of an approach that the then CEO, Mr. Lorgat, received. What was that all about?
Mr. Lorgat had been approached by two advocates who were acquaintances of Mr. Bodie and said that they could convince Mr. Bodie to come clean totally about monies paid. They then set up a meeting for the 17th of February. The bulk of the information on the video is what is contained in the video.
That's the meeting where on the left-hand side it was Mr. Bodie who did most of the talking. There was somebody sitting next to Mr. Bodie.
That was his new lawyer, Mr. Sinan Ngubi, I think.
Okay, and then there were two gentlemen that were sitting across from Mr. Bodie. I think the one had a purple shirt and the one had a pink striped shirt.
Mr. Yunus Mayete and Kieran Naik.
And who they were?
They were the two acquaintances of Mr. Bodie. They were both legal lawyers, I think, and they sat on the left to try and convince him to come clean. And during that meeting, he basically confirmed that, and it is evident in the video, that he confirmed that Mr. Bodie had approached these specific players. He said he went through the details of where they met, when they met, what they were paid, what they were supposed to do. That was basically the bulk of
and you outline all of that in 112 to 120. Again, in the interest of time, I'm not going to go through that. Save that. Just take us through paragraph 115, where Mr. Bodie mentioned the payments that various players got.
That refers to the meetings that Vicky, the frontman for the one syndicate, met with each of them to give them what we call a sweetener to make themselves available for the match in future in November. Mr. Mbalati later in his affidavit admitted that he'd received $2,500, which was the equivalent of 30,000 rand. Mr. Machikwe received 30,000 rand, Mr. Symes 30,000 rand, Mr. Tsotsobi 60,000 rand, and Mr. Tolekile 75,000 rand.
Did Mr. Peterson receive any money?
He was offered 50,000 on the 28th of October by Mr. Jain, but we had no evidence that he accepted money. So I cannot say that.
Then from paragraphs 121 to 144, you detail mirror images of the investigation. Again, I'm not going to go through each of that. All I can say is that the mirror images supported some of the information that you already got.
Exactly so.
Okay. Then in paragraph 145 to 147, you give details of affidavits you received from Mr. Machikwa and Mr. Symes, and then Mr. Mbalati. I think Mr. Machikwa and Mr. Symes was received on the 23rd of February 2016, and Mr. Mbalati was received on the 24th of February 2016.
Correct, sir.
Take us through that, please.
Mr. David Woodhouse, who I believe testified this morning, he represented all of those players. And we set up meetings on that particular day where we basically said to them that we have information that contradicts their versions. Mr. Woodhouse then requested an adjournment of the meeting, where upon they came back and said that they have to get consult again with their clients and
I think you're jumping ahead, Mr. Cole. We're dealing here with paragraphs 145 to 147, when I think that was a meeting or you receiving signed affidavits from those three gentlemen.
Mr. Machikwe and Symes indicated in their affidavits that Mr. Bodie had approached them and tried to persuade them to get involved in match fixing. They said to us that they declined those approaches, similar to what they told us when I initially saw them in December. Machikwe and Symes then indicated in their affidavits that Bodie had approached them, they declined, and that was the end of that.
And Mr. Mbalati?
Mr. Mbalati, I saw on the 24th, the next day, Mr. Beck and I received a signed statement, affidavit from Mr. Mbalati, from his attorney, Mr. Woodhouse. He confessed that Mr. Bodie had approached him, and his failure to report to me under the code, despite receiving education, he knew that was his obligation, and being aware of the contents of the code.
So this is now the sixth piece of information that you have that implicates the players.
Yes.
Okay. You then have a meeting on the 24th of February 2016. Who did you meet with?
I met with the driver of the one syndicate headed by Vicky, who Bodie got to drive them around Johannesburg and to meet with the players. And I gave him a photo board, which similar to the one on the video. I think it's on that one. So,
Sam, can you put up the photo board for us?
whilst we're waiting, I gave him a photo board, and I basically...
There's your photo board. Just take us through who's in the pictures from top. Go right.
Top left is Mr. Bodie, Mr. Etienne Belati, Mr. Craig Alexander, and Mr. Alviro Peterson. Bottom left is Mr. Tolekile, Mr. Tsotsobi, John Symes. And the person on the right was a person whom I thought his name was Banjo. I'll have to think what his name was, his nickname. He was sort of involved in the anti-Cronje match fixing thing at that time. It is just a random, and I needed to know whether he was part of it. I didn't.
So you showed this photoboard to Mr. Patia?
Yeah. What he then did is he indicated that Mr. Mbalati, Mr. Peterson, Mr. Tsolekile, and Mr. Tsotsobi and Mr. Symes had met with Vicky and the lot.
Who were Vicky and the lot?
Vicky and his set of bookmakers that had come to South Africa. The only person that he could point out that he was present with that received money was Mr. Symes. The others, he was asked to leave, or he was not in the room when the monies were paid.
How did it come about that you meet with Mr. Patia?
I think I must have asked Mr. Bodie how they got around. He said, he told me that he got Mr. Patia to go and pick them up at the airport when they arrived on the 20th of September. And he met them at the airport. They had come with Ethiopian Airlines, as you relate to me.
Okay. Then we see information about the mirror imaging of Mr. Tsolekile's phone. And as per your testimony earlier, the reason why this happens later than when the other players' cell phones were imaged. Take us through that.
Basically, can I just get your question clearer, sir?
So, as I understood it, earlier we dealt with the mirror imaging of various players' cell phones. Mr. Tsolekile's cell phone imaging didn't take place at that time because you said that it had been lost. But you then got a cell phone from him later.
That's correct, yeah. We then made a mirror image and we downloaded information which basically confirmed what we had alleged, that they had been offered money, that they were shown photographs of watches that they'd been promised as part of the sweetener. And then I also got confirmation that when they met with with Vicky Savant, that Bodie had made arrangement to meet him at Gautrain to pick him up. So it basically was a corroboration of the evidence that Mr. Bodie had given us.
Okay, so we spoke earlier about 8 independent sources of information. You then have the driver who drove people around, which became the 8th piece or source of information for you. And then the mirror image of Mr. Tsolekile's phone became the 9th source of information, correct?
That's correct, sir.
Okay. Then in paragraph 151, you detail a meeting you had. Just tell us who you met with and why.
150 is a long paragraph. Let me just scroll down.
151, it's a short paragraph.
I've got that. On the 5th of March, I then informally met with Mr. Nenzani, who was the president of CSA, and Mr. Arun Lorgat at a match at Supersport Park, where I basically updated them with the investigation up to that point. Informally, as I say, it was not a meeting that we'd arranged. I met them there and they asked me for feedback on what was happening.
As I understand, you included that in the affidavit because there were suggestions by some of the players during these hearings that Mr. Nenzani was not up to date with what transpired. Okay, you then have a meeting on the 7th of March. In fact, I think it might have been 2 meetings you had on the 7th of March. Take us through that. You start with those meetings at paragraph 153, and I think it runs until 160 or 161.
We then met with Mr. Machikwe and Mr. Woodhouse, where we basically said to them that the version that they had given us did not match up with the evidence that we had uncovered. We also said to him that it did not constitute a full and frank disclosure, and that information that we'd uncovered during the investigation proved the opposite. It basically said that the information that we got was that he had actually received money and was in contradiction to what he told us, that he declined the approach and that he knew nothing about that.
What then transpired? And you deal with that in paragraph 154 and 155?
Once we confronted him with the evidence, I think they also adjourned the meeting, and when they came back, Mr. Machikwe then said, look, I admit that what we're alleging, that is true, and that he wanted to make a full confession.
Okay. Who do you meet on the 8th of March, and what transpired at that meeting? I think you deal with that. No, sorry, it was a meeting, I think, later on the 7th of March, on the same day. You deal with that paragraph 156.
It was a meeting that I had. The one waited in the hall was with Mr. Symes, and we did exactly the same, said that we had certain evidence that we uncovered, and I informed him again that I was the complainant on Cricket South Africa's behalf in the criminal case. And we discussed at the meeting Mr. Symes' affidavit that we had received on about the 23rd of February. We then said to him the contents of that affidavit did not constitute a full and frank. It was actually, we had evidence to the contrary. It indicated that he had in fact met with Mr. Bodie at the Fire and Ice Hotel, and that he had received money, that he paid a commission, and we told him that the version that he told us was the concocted version that he had agreed with Mr. Bodie to tell. And then again, Mr. Woodhouse adjourned the meeting and came back later and said that he needed to get further instructions from his lawyer.
Okay. And did Mr. Woodhouse continue representing Mr. Symes?
No, Mr. Woodhouse was succeeded as by Mr. Will Clark. I don't know what the reasons for that was, but we then, after that, dealt with Mr. Clark.
Okay, then in paragraph 164, you give details of a discussion that you had with a then board member of CSA. Who was that?
I then met at a match in Cape Town. Cape Town of Port Elizabeth. I met with Mr. Vusi Pekole. He was at the time an independent director of CSA and also the head of the Social and Ethics Committee. And then I also was requested to give him an update of the investigation.
Okay. Then in paragraphs 165 and 166, you give details of a meeting that was had on the 15th of March 2016. Who did you meet with?
I met with Mr. Mbalati, and as with the others, we went through the same process, said that we had information that contradicted the affidavit that he'd given to us, and that he hadn't made a full and frank disclosure to us. Again, Mr. Woodhouse requested an adjournment and said that he needed to consult with Mr. Mbalati.
What transpired after that, the day after that meeting?
On the 16th of March, Mr. Becker was then advised by Mr. Woodhouse that Mr. Machikwe and Symes were willing to enter into discussions to agree on the sanctions that for the contraventions of the code.
Okay, and then you have a meeting with Mr. Symes and his new attorney. When was that?
That was on the 30th of March, and we met with Mr. Clark, and we then received a new signed statement from Mr. Symes, which basically was a direct contradiction to his first affidavit that had been given to us, and as a matter of interest, he is now being charged for perjury by the Hawks based on those two affidavits that he gave to us.
Did he implicate anybody else?
We're busy with Mr. Symes. He basically said that he'd met with Mr. Bodie, that he'd been handed an envelope, he took the money. His version was that he gave it back the next day to Mr. Bodie. And he said that he knew that Mr. Peterson, Mr. Tsotsobi and Mr. Cholikili and Mr. Peterson were involved in the match-fixing scheme.
Okay, so now you've got the 10th piece of information that even implicates Mr. Tsolakile and Mr. Tsotsobi, but now you've got direct information that's also implicating Mr. Peterson.
That's correct, sir.
Okay. Then on the 21st of July 2016, you concluded a sanction agreement with Mr. Symes. What was, just give us brief details.
He then basically just agreed that to a ban of 7 years from cricket. He signed, he had to sign a sanction agreement to agree to that.
Okay. When was your next meeting then with Mr. Mbalati?
On the 6th of April 2016, met with Mr. Woodhouse and his assistant, also again at the Protea Wanderers. And Mr. Mbalati then confessed that his previous affidavit was factually inaccurate. And he then gave us confirmation of the information that we had. And I think Mr. Woodhouse indicated this morning that he conceded that 90% of what we alleged was the truth.
Okay. So now this becomes the 11th piece of information that you have to charge the implicated players. In paragraphs 172 and 173, you then deal... let's do 172 first. You give details of a meeting that you had on the 7th of April 2016. Take us through that, please.
We had a meeting at Judge Ngwepi's offices, if that is the place, I think. We met with Mr. Arun Logart and Mr. Ngwepi, Mr. Becker and I, and we gave him an update of the investigation up to that point, where we also discussed the sanctions that had been put forward by Cricket South Africa.
At this stage, were you giving details of who you've decided not to charge?
Yes, we also discussed the other persons that I'd alluded to in my previous paragraph. I don't think it's fair to mention their names because I think it would be unfair towards them, but we also discussed that at that meeting.
Okay. Then on the 8th of April 2016, you had another meeting?
The 8th.
Yes, and that you detail in paragraph 174. Take us through that.
At that meeting, and I think it's also in the video, we met with Mr. Tolikile again. And at this meeting, he was represented by Mr. Lawrence van Zyl, who was his legal advisor. And I was under the impression that they were going to give us a signed statement. He refused to sign the statement, and it was just read into the record, and we have record of that on the video and the audio recordings.
Okay. Then on the 11th of April 2016, you receive another piece of information.
That became quite crucial, and Mr. Mbalati's lawyer sent us a video that I played on there, where it was a secret recording that a bookmaker had taken of Mr. Tolikile, where they discussed inside information, how many matches were going to be played and who was going to be involved in that.
That's the recording played against the black background?
Correct, sir.
Okay.
It was used to coerce them to get involved in further fixes.
So now with the information from Mr. Tolikile, which he read into the record, and in addition to this recording, you now have 13 pieces of information in order to charge the implicated players. Okay. Then you talk about another sanctions discussion or a framework in paragraph 177. Please take us through that.
As with the others, we then served Mr. Mbalati with a sanctions and offences framework, basically setting out the charges that we were going to pursue against him, and we gave them an opportunity to comment on that. It was part of the sanction agreement process.
And you did a similar thing with Mr. Tolikile?
On the 21st of April, the very next day.
Okay. Then you have a meeting on the 10th of May 2016. Who do you meet with?
Again with Mr. Ngwepe and Mr. Arun Logart, and also again gave him an update of the progress of the investigation.
Okay. Then you deal with a trip that you took to India in paragraph 182 and 183.
My assistance that I received from the ICC was that they engaged Interpol and the Indian police to assist me to track down one of the bookmakers, and that is the person that I saw, Mr. Manish Jain, in Mumbai. I think it was the...
He was the person with the yellow T-shirt, as I understand it, on
as
the
you
right.
look at it on the right-hand side.
Yeah. And who was the gentleman that he was talking to?
He was. There was a person in the background. He was the general manager of the anti-corruption unit of the ICC, and the person taking the statement down was Mr. Martin Vertegen, who was the head of investigations, intelligence at the ICC. We had interviewed Mr. Jain the previous day. That was in the office of the Commissioner of Police of Tani City. And the day after that, we then took down a statement and corroborated that with him.
Okay. So now you've got 14 pieces of information, am I correct?
That's correct, sir.
Thank you. Okay. Then on the 21st of July 2016, another agreement was concluded. With whom was that concluded?
What paragraph is that, sir?
184 to 187.
We then concluded a sanction agreement with Mr. Symes.
On what date was that?
And that was on or around the 21st of July in 2016, and then he agreed to a ban of 7 years.
Okay.
For various offences that Mr. Becker will probably talk about.
Okay, and then the next agreement?
Was on and around the 29th of July. We entered into a sanction agreement with Mr. Tsolekile, and he agreed to a ban of 12 years for a various range of offences.
Paragraph 186, you outlined the next sanction agreement.
On the 4th of August, we then entered into a sanction agreement with Mr. Mbalati, and he agreed to a 10 years ban.
Okay, and then on the 4th of August, there was another sanction agreement also concluded, which you detail in paragraph 187.
That was then with Mr. Machikwe, and he admitted to a range of breaches of the code, and he agreed to a ban of 10 years.
You wanted to make special mention of Mr. Machikwe during these hearings?
Mr. Ahmed, Mr. Machikwe impressed me as a person who was genuinely naive. And that
genuinely what?
Naive.
Okay.
That he'd been entrapped into this thing, this match-fixing thing, and even though he initially denied that, he then took full responsibility for what he'd done. He actually offered to pay the money back that he'd received. His heavy sentence at that point, unfortunately, was because he had received money from several of them. He'd paid commissions, he'd paid towards the legal fees for Mr. Bodie. But he showed genuine remorse, and he also, out of his own volition, I didn't approach him, agreed in terms of his sanction agreement to assist cricket with anti-corruption education. And he's the person right in the beginning that says what his involvement was. So he then was approached, I think, probably through SACA to assist cricket players in anti-corruption education, which would help them not to get entrapped in similar circumstances.
In paragraphs 189 to 189, you detail a media release that Cricket South Africa had issued.
That was on the 8th of August. CSA then gave a media release where they basically set out which players, Mr. Symes, Mbalati, Machikwe and Tsolekile, the periods that they were banned for, and it included apologies from most of them, except for Mr. Tsolekile, who refused to apologize. And then we also, as part of the media release, indicated that we could uncover no evidence that an actual fix had taken place. We might allude to it further, I'm not sure if we will. They got it wrong. I think
we are going to get to that. Okay.
Mr. Paul?
Yes, ma'am.
Did Tani's refusal to apologize affect his sanction in any way?
No, not at all, because by then he had already been sanctioned, and the media release was after that. And he basically, we could have pursued that if we could, because that would have been a breach of his sanction agreement, which would mean that it was null and void. We just didn't feel that it served any purpose doing that, so we didn't pursue that at all. Mr. Peterson later also did a similar thing where he went on national TV and made all sorts of allegations which was in contravention of his sanction agreement, and we asked him to not do that, and we didn't pursue that either.
Right. You deal then in paragraph 192 with Sports Radar.
Yes.
Just can you tell us what Sports Radar is and what information you've got?
Sports Radar basically is a company that I employed on the day that when Mr. Peterson told me something was going to happen. Basically, I had half an hour to do something about it. And I then contacted the ICC, who contacted Sports Radar Security Services. What they do is they monitor spikes in betting patterns to see if a certain incident occurs and whether there are increased betting patterns on that particular incident. And also it monitors the performances of individual players over their career to see, and they did that for us to determine that white ball that was indicated was highly unusual for a player of Mr. Tsotsobi's caliber, as at one stage he was the #1 ODI bowler. They indicated that that was unusual, but they also concluded that there was no evidence that in terms of the betting patterns that a fix actually took place.
Okay. You then, in paragraphs 193 to 217, deal with...
Excuse me, where is this Sports Radar thing?
In 192.
192. Yes.
Okay, and then paragraph 193 to 217, you deal with another meeting that was held on the 10th of August 2016. Who did you meet with? Where did you meet with? And just give us a summary. I don't need you to go through each paragraph.
Thank you, sir. By that time, it became evident to us, based on what we had uncovered in the investigation, that Mr. Peterson wasn't the whistleblower that he purported to be. And we then...
Can I ask you why you say that? Because he is the guy that volunteered the information that he was approached by Mr. Bodie.
It was based on many things. The initial information that he'd given us, which was not a full and frank, we then could, in retrospect, as the investigation progressed, we found out that what he'd initially told us was disingenuous and not the truth. And as we went along, he'd met with Manish Jain, and he didn't tell me, in fact, the day that he met with Manish Jain, I phoned him in the morning and he said to me, Louis, I thought you said that you were going to end this investigation. I said I couldn't without information. Got off of the airport, went home and went directly and met with Mr. Manish Jain. And he didn't tell me, he was my whistleblower. So as the evidence came, we came to the conclusion that Mr. Peterson was not being truthful and that we had to go and interview him to verify some of the inaccuracies.
Okay. And so you get further information at the meeting of the 10th of August 2016, and on the basis of that, you conclude that your 4 or 5 previous interactions with him did not...
That is correct, sir.
Okay. What role did that play in deciding whether or not to charge him?
Well, that... we saw him over a period of 2 days as well. The first day was a long process that we followed with all the others. We asked him for his version. We gave him what we had and said, based on what we have and the WhatsApp messages and what Bodie had told us and everybody else, what his versions in his affidavits were just not the truth. He then conceded that he had met Mr. Manish Jain on the 29th. He couldn't give me an explanation or us an explanation as to why, as my whistleblower, he didn't divulge that to me. He admitted that he'd met with Mr. Bodie and Vicky, the other syndicate, on the 4th. And he couldn't give me an explanation why he didn't tell me immediately the previous day. So he made a range of admissions to us, which finally confirmed that he was not a whistleblower in the true sense of the word, but he was actually a participant in these
So
meetings.
if I'm counting correctly, this is now the 15th source of information that you had.
That's correct, sir.
To charge the implicated people. You then deal with, in paragraphs 208 and 209, where you receive from him a concession about the meeting that was held on the 4th of November 2015. Take us through that.
Can I just get there quickly? 208 and 209.
Yes.
He then confirmed to us, he conceded that he had actually met with Mr. Bodie and Vicky at the Mug and Bean. He confirmed to me that contrary to all his previous failures to report that to me, he confirmed that he'd been offered 100,000 Rand. He confirmed that he actually mentioned 300,000 Rand. He rather wanted that. he had an explanation for us to say that he wanted to throw a figure which these guys couldn't meet. And it seemed like a plausible explanation. We didn't have information that he went further than that. So we didn't charge him for that. As I correctly remember, I think Mr. Becker would probably go into the detail of that.
Why did it matter that he didn't tell you during your call in the morning of the 4th that he's meeting Mr. Bodie?
It was such a material omission, Mr. Ombud. Both the meeting on the 28th of October with Manish Jain and the meeting of the 4th of November with the other syndicates. If he had told me, because the arrangement for the meeting at Melrose Arch for the 28th was made 2 or 3 days earlier via WhatsApp, they had a discussion about this whole theory of the Alvera Peterson Academy. If he told me then, I would have arranged with the Hawks to have Mr. Bodie arrested at that point, as well as Manish Jain, the one syndicate. That would have ended the investigation right there. It would not have proceeded to a point where they actually tried to fix the match. The same with the meeting that he had at the Mug and Bean on the 4th. If he had told me the previous day, he WhatsApped me and said that he saw Mr. Bodie. Didn't tell me that he had lunch with him and discussed match fixing. I would have been able to get the Hawks to arrest the other. They then left the country and it was impossible to hold them accountable.
So in essence, he told you about 7 to 8 months late.
Correct, sir.
How different is that from Mr. Alexander and Mr. Van Jaarsveld?
That's where I mentioned earlier that the determination as to whether it is a report without unnecessary delay. The code makes provision for that.
Which code?
The anti-corruption code, sorry.
Oh, yes.
It makes provision for that under that clause where it says that the circumstances of each late report will be taken into account. 8 months or 2 days versus a material omission where I could actually have the people arrested or detained. That is what was seriously the difference between the two approaches.
In paragraphs 211 and 212, you give details of a concession that gets made during your interview of Mr. Peterson on the 10th of August 2016 and his explanation. Please take us through that.
During the forensic download of his phone, Mr. Peterson's phone, I uncovered that he had deleted 188 WhatsApp messages referring to all interactions with Mr. Bodie. So everything was deleted on one day. On or very close to the date that I had met with Mr. Bodie the first time on the 6th of November, where he then phoned everybody and said, listen, Louis is investigating. It was a material omission or act, and he was then charged for obstructing the investigation on that.
So, as I'm understanding your evidence, Mr. Cole, and I'm just repeating what you told us earlier, with Mr. Van Jaarsveld and Mr. Alexander, they were approached by Mr. Bodie. They rejected the approach,
yes, sir.
But they may have been late in reporting to you. But eventually, in discussion with Mr. Lorgat, Judge Ngwepe, and Mr. Becker, and in consultation with the ICC, you decide not to charge them. Mr. Peterson's situation was very different because you had 4 or 5 engagements with him, including one statement that was prepared with the assistance of his lawyer.
Correct.
And during those 4 or 5 interchanges, a lot of the detail was not revealed to you. And it's only you getting that detail from other people and then confronting him with that information at the interview of the 10th of August that he then spills the beans.
Yes, sir.
Okay. In paragraph 211, so we were going, you say he conceded to obstructing or delaying the investigation by withholding information.
He basically couldn't give me an explanation. He said that he had deleted them, but he couldn't give me a rational explanation. The explanation just didn't hold water for us. It was too material. in terms of the timing of the deletion.
In fairness to Mr. Peterson, he gave some explanation.
He did.
You may have not believed the explanation,
Yes,
or you didn't think it was a credible explanation, but you go through the explanation he gave you in paragraph 212.1 to 212.3. I think in fairness to Mr. Peterson, let's just give that explanation, please.
We did, after we had spoken to him on the following day and said that there were certain charges that he could face, but that we would first have to deal with those charges with his lawyer, and also we had to go back to Mr. Lorgat and Mr. Ngwepe to discuss these revelations to us to determine whether in fact we were able to then charge them with the offences that we thought that we could.
Okay, in paragraph 214, he gives an explanation for having had a number of meetings with Mr. Bowdy and the bookmakers.
Mr. Ahmed, initially when he reported to me on the 12th of October, he said that he feared for his life and he feared for the life of Mr. Tolekile and their families. And then he gave us an explanation for his continued meeting with these bookmakers whom he feared, that he said it was out of curiosity. Now, if you fear somebody, but you go and meet them because you are curious and you continue to engage them, that was on a balance of probability. We thought that was not an explanation that we could believe. If I fear somebody, I will cut all ties with him, but that was his explanation for his continued engagement.
In paragraph 216, you give details of another discussion that you have with Mr. Peterson. When did that happen?
216.
Yes.
That was the following day where we basically summed up the charges that he could face. He started the meeting in the morning where he thanked he thanked Mr. Becker and myself for the way in which we conducted the meeting the previous day. As we went through the possible charges, he became very emotional, and I got the impression he actually became tearful. I got the impression that he, for the first time, realized the enormity of the charges that he faced and that it could possibly end his career.
There was then a further meeting with Mr. Peterson, but this time with his lawyer on the 10th of October 2016, and you deal with that from paragraph 218 of your affidavit.
Subsequent to our meeting in Manchester with Mr. Peterson, we then, as I alluded to, we had to discuss it with his lawyer. We met then again at his offices on the 10th of October.
When you say his offices?
Mr. Twaddle's office. He gave us a supplementary statement signed by Mr. Peterson, and we then also discussed possible sanction offences. We couldn't reach an agreement because Mr. Peterson felt that the sanctions that we proposed was too severe, and that he felt that he would rather go to a tribunal.
Okay.
He was Twaddle. Was he the lawyer?
With his lawyer, Mr. Peterson and his lawyer felt that what we proposed was too severe. I think the possible ban of 7 or 10 years, I can't remember, was proposed, and he felt there's no ways he was going to admit to that. He would rather contest in a tribunal.
Yeah, what I was seeking to find out was the lawyer, Mr. Twaddle.
Twaddle, yeah.
What firm is he from?
What?
What firm of attorneys is he from?
I think he works for himself. I'm not entirely sure. I think he has his own firm. I'm not sure.
But he was the lawyer?
He was the lawyer, yes, sir.
Okay.
I'm sure Mr. Becker may be able to shed more light on that tomorrow. So you don't reach an agreement, you then charge Mr. Peterson, presumably?
We did, yes.
Okay, and what then happens?
Mr. Becker really dealt with the legal issues, but on the 12th of November, we then charged him for various offences and served him with a notice of disciplinary charges against him, and we gave him 14 days to respond to that, and it was then on his request postponed to the 9th or so of December.
Okay, and did you finally conclude an agreement with Mr. Peterson? Please take us through that.
Mr. Peterson then signed a sanction agreement with CSA, and he was then banned for 2 years.
How many charges did he plead guilty to?
I'm going 13 charges, sir.
Did he have any assistance, legal assistance, before he agreed to the sanction?
I would prefer Mr. Becker to deal with that. I was not really involved. I had communication with Mr. Becker on what they were doing, but I cannot remember that detail. That was his...
Okay. Now let's get to the heart of some of Mr. Peterson's allegations during these hearings. Mr. Peterson suggested that he was charged for reporting late because he reported to Mr. Irish on the 8th of October, but he did not report to you on that day. What do you say to that?
I think I did deal with that. At the time, there was a practice where, in the absence of an anti-corruption officer, it was reported to SACA, but as I got on board, I reminded Mr. Breetske and also Mr. Tony Irish later that the code only constituted a report if it was reported to me. So it specifically refers to that. It will not constitute a report unless it is reported to the anti-corruption officer. I told him, and that was what the code had said.
In paragraph 228, you detail in your affidavit that Mr. Peterson suggested that he was not given the information that he required for the purposes of defending himself, and then suggested that that's why he ended up doing the plea bargain or sanction agreement.
Yeah,
your response to that?
I beg to differ. We did send him a transcript. I think he might have referred to the meeting the next day, which was a without prejudice meeting, and we said that we would rather discuss that with his lawyer, which we did.
Okay, you talk about the gratitude that Mr. Peterson expressed in paragraph 229.
Yeah, I mentioned that earlier, that the meeting the next day, I think it was 11th, he started the meeting by saying, I just want to thank Mr. Beck and you for the responsible way in which we dealt with the meeting the previous day.
Then in paragraph 230, I deal with a part of Mr. Peterson's evidence where he talks about CSA refusing to give him a public hearing, and he had no faith in getting a fair hearing. What are your responses to that?
Mr. Ahmed, the anti-corruption code is very clear on the hearings. The hearings is the internal hearings is a confidential matter, and there was no question that it was going to be public hearings. So I just think he doesn't know what the code says.
Please take us through what you record in paragraph 235 of your affidavit.
Mr. Peterson said along the way, I only personally dealt with his one lawyer, Mr. Twaddle, but I think in his submission he says that he was ably represented by 2 advocates and 2 attorneys. I only dealt with Mr. Twaddle.
Then Mr. Peterson insinuated during the hearings that he was pressured into signing the sanction agreement. What are your comments in relation to that allegation?
I think if someone is represented by a strong legal team consisting of 2 advocates and 2 attorneys, I would be very surprised if they would concede to any threats of intimidation or coercion. I just don't think that could ever be true.
Were there such threats?
Never, sir. I deny that. One can see the manner in which Mr. Becker and I dealt with the meetings in the video, that we explained to each of them what the process was, that the police was involved, that we didn't want to coerce them, that we gave them an opportunity to raise questions. That is not true.
Then in paragraphs 237 and 238, there's reference to Mr. Peterson saying that a motivating factor for him agreeing to accept the 2-year ban was that he was going to be allowed back into the system by Mr. Lorgat within a year.
I wasn't present at that meeting, so I cannot really comment on what he alleges happened, but I can comment on the process. The process just would not allow for that. The ban was recognized by the ICC, and it would mean a legal process to have that altered. I don't think Mr. Lorgat would be in a position to do that on his own.
Mr. Peterson.
Is that a typo at 237?
237.
That 5 there, I was trying to...
I think it's the footnote. It's meant to be the footnote.
Okay. Yeah, all right. Okay.
I think Helena's got to take responsibility for that, Mr. Chair.
Right, okay.
Okay, then in paragraph 239, we deal with the allegation that Mr. Peterson made, or he complained that you and Mr. Becker had grouped him together with other corrupt players. What's your response to that?
Technically, he could be correct that he was grouped together. All the players were charged under the Anti-Corruption Code for participating in corrupt behavior. Now, corrupt behavior is defined in the Anti-Corruption Code as such. Any act or omission that would amount to an offence in terms of Article 2 of the Anti-Corruption Code, or the equivalent provisions of the anti-corruption rules of the ICC or any other federation. So the code defines what corrupt behavior was. He was found guilty and admitted to participating in corrupt behavior. So if he was lumped together with the others, he did that by himself.
Mr. Peterson also complains that the last time CSA charged people with match fixing or similar offences, the people other than Mr. Cronje, who was the person that was charged, got 6-month bans. And, so on that basis, he contends that the 2 years was too harsh, and the fact that he is black may have had a role in determining the sanction. What do you say to that?
Well, that simply you cannot compare apples to pears, because at the time in 2000 when Mr. Cronje was found guilty, it was also at a commission. There was no anti-corruption code at the ICC available, and therefore one cannot compare the one with the other. And at that time, there was no anti-corruption education given to players, whereas in our circumstances dealing with this investigation, Mr. Peterson, as an international player, received all international players, but he was one who had an extended period playing for the Proteas, was given extensive anti-corruption education by the ICC and also by me before every domestic competition. We go through that whole thing. So there's a distinct difference in that one. There was also
in those.
Sorry, sir.
In those engagements, would the anti-Cronje issue be raised as a lesson that they must take into account in their conduct of themselves, insofar as anything that would be suggestive of corruption was concerned?
Yeah, I think during our education sessions, it is referenced quite a lot that this is what happened to him, and we must be aware of these practices, because this could be the outcome of that. So it's part of our anti-corruption education, sir.
Yes.
Okay, then in paragraph 243, you make a point of quoting from a press release on the that was released on the 21st of December 2016.
After Mr. Peterson had been sanctioned, we then agreed with his lawyers to release an apology on his behalf. And do you want me to read through it, sir?
Please.
He says, Mr. Peterson, I would like to apologize to my family, friends, the public who are fans of the game of cricket, my teammates, Gauteng Cricket, Lions Cricket, and especially to Cricket South Africa for my actions. At the time that the meetings with Mr. Bodie and the fixers that happened, I never had the intention of fixing matches or taking money. I now deeply regret having participated in these meetings and not to have reported them immediately to the authorities, as I am obliged to do. I understand that I need to take personal responsibility for my actions, and I accept the punishment that CSA has imposed on me. I hope that other players will learn from my experience and be better prepared if they find themselves in my situation. and that my punishment will serve as a deterrent. I also wish to thank my family, my friends, and my legal team for their unwavering support and guidance during the last few months.
Did you get the sense from that press release that Mr. Peterson felt that you and Mr. Becker were racist against him?
Not at all. He actually acknowledged that we had acted fairly, and he thanked everybody, including CSA.
In this press release, but there was an earlier occasion as well.
I'm not with question of.
So, as I understood Mr. Cole's evidence earlier, he also thanked you on the 11th of August in
Correct,
Manchester.
Yeah, he thanked us personally for the way that we dealt with him during our investigation in Manchester.
Okay, I'm not going to deal with the Mr. Van Jaarsveld issue. We've taken you through that and you've explained the differences.
Yes, sir.
Okay. You just want to take us through then paragraphs 249 to 254 of your affidavit?
249 and 250.
Yeah.
Yeah. Mr. Ahmed, Mr. Peterson is clearly a very intelligent person. I was really impressed with his knowledge of the code, and I would have expected more from him. And his version, as opposed to what he admitted to, was not consistent with what had happened. And then for him then to try and tarnish my reputation is, in my opinion, very unfortunate. He then says that Mr. Ntsebeza knew nothing about the investigation. As part of our updating process, as the investigation developed with regard to each and every player, Mr. Beck and I had input on updates, official updates that had been provided to Mr. Harun Lorgat. We in turn then would provide that update to the board, the cricket board. Mr. Ntsebeza, who was the president, had to sign those updates that we had supplied. He had to update them. We, in the process, had made about 6 different updates that we gave that Mr. Ntsebeza signed. And then there were many, if I say, let me just count, many press media releases which also gave updates which would have been cleared by Mr. Ntsebeza. So there's no truth in the matter that Mr. Ntsebeza knew nothing about the investigation.
Okay. Mr. Peterson suggested during the SJN hearings that if there was another investigator that dealt with the investigation, he would not have been charged, and that investigator would have come to a different conclusion vis-a-vis you.
I beg to differ, because as I've put out before, we had a lot of evidence, and as the Ombudsman might appreciate, the standard of proof in the internal investigation is that we had to be comfortably satisfied that on a balance of probability what we alleged was the truth. We had sufficient evidence. There was another investigator from the Hawks who investigated a criminal matter on a higher standard of proof, that they had to prove beyond reasonable doubt with what was alleged by the state. Mr. Bodie was sentenced to 5 years imprisonment on that. So I'm not entirely sure that any other investigator in the internal matter would have come to a different conclusion.
In paragraphs 255 to 257, you deal with the criticism that Mr. Peterson leveled against you during these hearings for not stopping the game that occurred on the 4th of November 2015.
Mr. Ahmed, based on the information that Mr. Peterson gave to me 30 minutes before the start of the match, that he'd overheard in a language that he didn't understand figures which he put together and he detailed the information that he allegedly overheard, even though he conceded in Manchester that he didn't understand it and he only heard figures. He gave me a detailed account of what he thought was going to happen, which coincided with the information that Mr. Bodie gave on video, where he said if the Lions bowl first, this is going to happen. If the Lions bat second, bowl second, this was going to happen. So in light of what he gave me, there was no ways, and the time that he gave me, that I would be able to stop. There are contractual obligations with broadcasters and so on. Even if I had intervened, we still only had the word of Mr. Bodie and Mr. van Jaarsveld, so we would not have been able to stop that match at all. I immediately contacted the ICC, Mr. Martin Vertingen, who took the statement down, and he then assisted us to activate Sports Radar, who then gave us a report afterwards as to what they thought had happened.
In 260, you deal with Mr. Peterson suggesting to these hearings that you and CSA are dishonest because you reported to the media that no match fixing took place. Your comment on that?
Again, we had no concrete evidence. Mr. Bodie told us that there was absolutely no chance that a fix had taken place. So I had absolutely no evidence and I've also found no concrete evidence. If something had happened, it would not have been to my knowledge at that point.
Mr. Peterson also testified during these hearings that he was discriminated against because you or Mr. Becker tried to prevent him from commentating on SABC.
I'm not going to read there, but I first got to hear of that when Mr. Peterson had completed his ban. His ban, 2 years ban had been completed, and then he wrote a letter to Mr. Jacques Fall, who was the acting CEO at the time, complaining that Mr. Becker and or CSA, or I'm not sure, had intervened and tried to stop his employment as a commentator with SABC. I investigated that because Mr. Fall forwarded the matter to me, and after consultation with the Social and Ethics Committee Chair, Mr. Cornelius, I investigated that, and I found that he also alleged that his accreditation had been withdrawn. I spoke to the accreditation manager who said that it had in fact been issued, so it was not the truth. And also I then contacted Mrs. Melinda Lombard, who works for the SABC. Just want to get a title.
Paragraph 268.
268, and she basically said to me, she is the executive producer of sports projects at the SABC. I asked her whether somebody from CSA had tried to intervene and stop his employment. She said that that was not the truth. Nobody from CSA had approached her. She recalled having a meeting with Mr. Peterson, where she asked him whether the match-fixing allegations had been completed. He confirmed that, and they made that's what she conveyed to me. They made an operational decision to use him in studio instead of an on-field commentator.
Can I get you to comment on the fact that of the implicated players, the vast majority were black?
That we charged.
That you charged?
Yes. It was only Mr. Symes that was a white person.
Okay, and what's the justification for only having 6 black players and 1 white player charged?
Well, as Mr. Bodie alluded to in the video, he said that he approached the following players. I sort of gathered through my investigation that the players that he approached were friends or he had a relationship with them. And he informed us at that meeting of the 12th of February that he approached each one systematically, and in the interviews that we had with him and the WhatsApp messages that we have, he details the appointments that he made with them and discussions relating to why he was going to meet them. It sets out the dates that he met with them. So we just followed the evidence as it was given to us.
In paragraph 272, you make a very serious allegation against Mr. Peterson. Can you tell us what you're alleging and why?
Mr. Peterson claims, and he's adamant in his testimony, that a match fixing had taken place. As I said, that I could not uncover any evidence to that effect. And the effect of that is there's an obligation on anybody who has information that he has to report it to the anti-corruption officer. He did not report that to me. His specific knowledge, because the evidence that I uncovered was that it was a botched attempt on the 4th. They got it wrong, so there was nothing. If he had evidence that something happened, he was obliged to report that to either me, and in terms of the Criminal Act, the Prevention and Combating of Corrupt Practices Act, he has an obligation to report a corrupt approach, which he didn't. So he would put himself at risk of being charged for that, if he did in fact have information to that effect.
Okay. In paragraph 273, you deal with Mr. Tsolekile. You deal with that from 273 to 287. I'm not going to go through all of that detail because, as I understood it, Mr. Tsolekile did not volunteer that information before these hearings. All that happened was, I think in the questions that had been raised, there was a reference to a paragraph in his affidavit which suggested that he was unfairly treated. But I'm not sure that that allegation of unfairness follows, and there's the suggestion that he was unfairly treated because he was black. I didn't get that impression, but I think you've set it out in your affidavit, and the chairperson will have regard to it if he thought that that
Can I just comment on the allegation of unfair treatment by us towards him? He had several...
And especially if it suggests or doesn't suggest that it was because of the color of his skin.
I think that's why I included that clip in the video where Mr. Becker, in the presence, I'm not sure if only Mr. Van Zyl was there, but in the presence of or his lawyers, he goes at length to say that the reason why we're investigating this is that there are allegations. He gives him an opportunity to comment on that. He says we don't want to be unfair towards him. He doesn't care who they are. We have to protect the game. That is the trend, how we dealt with those meetings.
But let me take you to paragraph 286, because there is a suggestion that you, Mr. Becker, and you know that there were a lot more other players were involved, but only black players were targeted, and those black players were treated unfairly.
Yeah, I think in the before the hearings, Mr. Tsolekile alleges in his oral evidence that Mr. Becker himself knows and Louis Cole knows that there are a lot more other players that are involved, and in the process itself, black players were targeted and they were unfairly treated. I obviously deny that they were unfairly treated, that we targeted them. It's clear from the evidence that that is just not the case, and I absolutely reject that allegation.
Is it fair for me to say that if that allegation was true, and if one bears in mind that Mr. Van Jaarsveld and Mr. Alexander were singled out during these hearings, the other players that were involved would also have been singled out? By them not singling out the other players, you can't deal with why they have not been charged by you.
Yeah, that's correct, sir.
You then deal with Mr. Tsotsobe, and you say in paragraph 291 that on the 21st of June you received information from Mr. Tsotsobe's attorneys. Please tell us about that.
Mr. Tsotsobe, along the way, was very uncooperative after the first meeting that we had with him, and he just went AWOL. He disappeared. His coaches couldn't get hold of him, his lawyers couldn't get hold of him, and ultimately we found out that he had changed his lawyer, and we then got in touch with Mr. Gous, who was representing him. Mr. Gous was briefed, let me see.
Paragraph 282?
292, yeah. Mr. Terry Price was briefed by Mr. Gous, and we had a fairly short meeting. It could have been under an hour. We again presented the evidence that we had. They convened, adjourned the meeting, came back after half an hour and said that they were prepared to enter into a sanction agreement with us.
Is Mr. Price an advocate?
He sadly passed, but he was an advocate at the time.
Okay, and do you know whether he was a senior or a junior advocate?
I think he was a senior advocate, senior counsel.
You then talk about what transpired after that meeting, or just at the end of that meeting in paragraph 294.
What I alluded to, they adjourned for a short while. They must have had a discussion, and they came back to us and said Mr. Price was part of that meeting. Him and two other lawyers, Mr. Gous and somebody else, Mr. Becker will know. They came back to us and we had a short meeting. He said that they are prepared to plead guilty to the charges and sign the sanction agreement.
You then deal with who you liaised with in regard to that sanction agreement.
The same as with
295.
Yeah, the same as with most of the players. Once we started considering the sanctions with each of them, we consulted with Mr. Lorgat, with Judge Ngwepe, and Mr. Ian Higgins, who was the head of legal of the ICC, and we then determined what would be an appropriate sanction.
In what capacity did you consult with Judge Ngwepe?
He was the head of the independent head of the anti-corruption unit.
Yes. Okay.
Yeah.
And Mr. Tsotsobe was under the impression, and certainly suggested to these hearings, that he didn't want to go through a disciplinary inquiry because Judge Ngwepe, who was really your man, was going to chair that inquiry. Your comments on that?
Yeah, again, I think the same as with Mr. Peterson, I think it was. He just didn't know what the provisions of the code said. The code says it has to be independent people on the panel. Mr. Ngwepe would disqualify himself. Mr. Becker would disqualify himself. It would be a chairperson who could be a lawyer or an advocate according to the code, and he could appoint 2 or 3 people to sit on the panel. So it would be a totally independent tribunal.
In paragraph 298, you deal with the allegation in Mr. Tsotsobe's document that suggested that there was a flaw in the process because Judge Ngwepe was not involved in the conclusion of the sanction agreement. Your comments about that, please?
No, that is just not true. Mr. Ngwepe was involved in making the decision as to what an appropriate sanction would be. Mr. Becker would certainly have not entered into discussions about sanction agreement if he had not first discussed that with Judge Ngwepe and Mr. Lorgat.
I'm not going to deal with Mr. Tsotsobe's allegation that Mr. Van Jaarsveld was treated differently from him, because I presume that your explanation is the same.
It is the same.
If we go back earlier, I mean, there were 15 independent sources of information which allowed you to charge Mr. Tsotsobe if you wanted.
I think the allegations, the players were just not aware of...
I'm sorry. Just in paragraph 300, I just want to be sure that we are on the same page.
Yes, sir.
What we understand by what you say. While Mr. Van Jaarsveld may be criticized for reporting after 2 days, he immediately declined Mr. Bodhi's approach. What do you mean by that?
Both Mr. Alexander and Mr. Van Jaarsveld were approached on the 12th of September by Mr. Bodhi,
yes.
And they said no. I want nothing
Okay.
I want nothing to do with this. And they then...
in other words, he rejected.
He rejected it immediately.
Yes, okay.
It took him 2 days to report it, for the report to come to me,
okay.
and 2 months for
All right.
Mr. Alexander.
Yes.
Okay, Mr. Tsotsobe also alleges, and I'm referring to paragraph 301 of your affidavit, where in paragraph 25 of his unsigned affidavit, he alleges that he was intimidated by Mr. Becker. I'm sure that Mr. Becker will talk for himself, but
I was present at all times.
Yeah, so can I just ask you for your take on that?
If the Ombudsman will remember that I initially met with the police on the 27th of September, formally opened a case on the 27th of October. The case was, the second one was an inquiry. The case was officially registered with the police in June of that year. And so every single person was informed by us that it was that the investigation was subject to a criminal investigation, that all information I had. So they already knew that. So to allege that we threatened them, that we would open a case and that we would go to the police just doesn't make sense, because I cannot threaten somebody that I'm going to do with it if it already been reported.
Okay. You then deal with the criticism that was leveled during these hearings by Mr. Tsotsobi about an insurance fraud. And he suggested that that was raised by you and Mr. Becker in order to coerce him into signing the sanction agreement. Your comments about that?
Yes, sir. In terms, as I mentioned, in terms of the code, I am allowed to share any information that I gather with the police, which I did immediately as I reported it to the police. I then have an obligation, also in terms of the code, that if there are indications of a criminal act, I have to share that with the police. So there's an obligation on me as the investigator to do that. In terms of, the Prevention and Combating of Corrupt Activities Act, it says that if knowledge comes to my attention, of a fraud being committed to the amount of 100,000 rand, there's an obligation on me to report that to the police. I did that. And the reason that I did that is that at the time, there were indications all along through WhatsApps and discussions with Mr. Bodie that Mr. Tsotsobi was in serious financial difficulties. And that the monies that he was collecting from the bookmakers, a lot of money over several amounts and dates, was used to alleviate that financial problem that he had, because at a certain time, this urgency of his financial problem dissipated, and therefore, for me, there was direct link between the information that I had and that I shared. So it's not true to say that I used private information to pursue criminal charges. I did that early in April, long before he raised it with his lawyer.
Then in paragraph 309, you comment on Mr. Tsotsobi's suggestion that you and Mr. Becker promised that no criminal proceedings would be pursued if the sanction agreement was concluded.
On the same vein, as I said with the criminal threat that we threatened them with criminal matters, the matter had already been reported to the police. The Bodie had been charged, and as the complainant, I gave them a statement, and I indicated specifically in my statement all the evidence that I had which led to Mr. Tsotsobi, etc. So they knew exactly who was going to be charged. And for the same matter, the investigating officer of the Hawks, he collects information similar to what I did on the internal matter. And the NPA decides who to charge. I have no control over those procedures.
Yes, Mr. Wilson.
Yeah. In paragraph 317, you give further details about an affidavit you've submitted to the Hawks.
317.
Yeah.
So on page 78.
Yeah. Oh, Mr. Belati, I hope I answer your question, sir. Mr. Belati claimed that Mr. Beck and I had taken advantage of his vulnerable situation when we charged him, etc. Mr. Belati
Are you
was
dealing with paragraph 317, because that's a paragraph just before.
That's still dealing with Mr. Tsotsobi.
Mr. Tsotsobi.
My numbering might be wrong. I'm sorry. Can you just?
It starts as the complainant in the criminal case on behalf of CSA.
I think I might have.
And it's required by the Hawks. I submitted
I've got it. Thanks.
120-page affidavit.
I've got that. Yeah.
You've got it.
Yeah. The investigating officer of the Hawks came to me for a week to try and construct an affidavit, and it contained 120 pages, and there were about 110 exhibits. And the involvement, as I've discussed during my evidence now, involvement of each and every player, including Mr. Van Jaarsveld's approach, Mr. Alexander's approach. As I said, my affidavit here is in some instances a copy and paste of my criminal case. So they knew exactly who I alleged based on what evidence, and that was my complainant statement. The Hawks then would have done their own investigation to see whatever witnesses they deemed fit to do that. And pursuant to that, Mr. Bodie has been sentenced to 5 years imprisonment of a maximum of a possible 15 years. And then I know that Mr. Symes is appearing tomorrow on 5 charges of corruption and also for perjury. Mr. Machikwe has also been approached by them. I understand, I haven't got that detail yet.
Okay. Then in paragraph 318, you deal with paragraph 56 of Mr. Mbelati's July 2021 affidavit, where he alleges that Mr. Becker and you took advantage of his vulnerable position.
It will be my 317. Yes. Mr. Mbelati wasn't in a vulnerable situation. He admitted during my interview with him that he had been educated under the anti-corruption code. He knew exactly what was right and what was wrong. He was implicated by Mr. Bodie, Mr. Peterson, and Mr. Manish Jain. We had cell phone records to corroborate the evidence. He was dishonest with us. He told us a different version. He gave us another statement. And after he was caught out, he only gave us the second statement, and he confessed to receiving monies from the bookmakers, meeting with them, agreeing to participate, and failing to. So he was not. If he was vulnerable, it was of his own doing. In Mr. Woodhouse's evidence this morning, he contradicts all of this. He said he knew exactly why he was charged, and he was indifferent as to whether he was charged for 5 years or 10 years. He said that his career was at an end.
Then in paragraph 320, which starts, during these SJN hearings, Mr. Mbelati referenced the 6-month bans that were given to Herschel Gibbs and Henry Williams, who were implicated during the ANC Cronje scandal. You've dealt with this. Just very quickly, just repeat why he didn't receive such a lenient sentence.
The ANC Cronje thing again, there was no anti-corruption training and there was no ICC code. So the King Commission would have probably taken that into account. It was a huge thing in South Africa.
Okay. Just can you read from paragraph 11 of the affidavit that he had deposed to on the 24th of February 2016, and you referred to it in paragraph 321 of your affidavit. It starts by 2015. I just want you to read what he says in his affidavit.
He says, I confirm that I have received anti-corruption education by Cricket South Africa, or by SECA, sorry. I am aware that I am bound by the Anti-Corruption Code of Cricket South Africa and that I am obliged to report any knowledge of corrupt activities or approaches made to me and to get me involved in corrupt activities. I am furthermore aware that I have to cooperate with the designated anti-corruption official.
Then in paragraph 322, it starts, Mr. Mbelati also suggested that...
Mr. Cole?
Yes.
When did players receive the anti-corruption education?
Over an extended period. As I say, the international players receive before every international tour, incoming tour, or if they go to another country, they receive by the anti-corruption official of the ICC, they receive the education. The domestic players, I started with, SECA started way before I started because there was no code in place. They would then have used the template or the ICC template. And once I got on board, I started drafting the CSA anti-corruption code, which was based on the ICC one. I started giving them, and I think before the scandal started, I had given them, the players, one education session before the start of a competition, based on the draft that I had been using, which was a replica of the ICC one.
Is it? So I know from the affidavit you say that the CSA's anti-corruption code was adopted on the 1st of September 2015.
That's correct, ma'am.
So when would the education in terms of CSA's code, when would that anti-corruption education have taken place?
I would have used the draft, as I said, which basically, as I say, it was a copy and paste thing, because the only thing that differed from the ICC's to mine was the jurisdiction. In other words, if there were international players involved in that, the ICC then does the investigation. Whereas if it's a domestic thing, which was the case with our investigation, I would then do that. But I used my draft, which was based on the ICC one, to give them. It is all those principles of they shouldn't get involved in corruption, betting, inside information. It's a copy and paste of the ICC one. So the principles were all the same.
So the CSA didn't have a code of its own?
Until the 15th of September, when it was officially, did I say the 15th? In September, 1st of September, sorry. It was then officially adopted by CSA, but it had then gone through a whole process to have it validated and accepted.
You still wanted to ask a further question?
Thanks.
Mr. Cole, you then deal with Mr. Mbelati referencing the 6-month bans, and you've answered that now. And thereafter, you talk of changes from about 2015. Just take us through that. It's paragraph 320 in my version, starts by 2015.
It starts with?
By July 2015, this has changed significantly.
Okay, just let me get this.
What paragraph is that?
321.
Oh, okay. Yes.
Oh, that was in reference to the anti-Cronje thing. By 2015, as I said, on the 1st of September, CSA had adopted the anti-corruption code. By then, players would receive regular education domestically by me and internationally by the ICC anti-corruption officer.
Okay. You then had you respond to Mr. Mbelati's suggestion that Mr. van Jaarsveld had preferential treatment, but you've taken us through that a number of times today. Presumably, it's again reported a few days late, but he rejected the offer that Mr. Bodie made, and secondly, he had played open cards with you once he had reported, and he accepted no money from the bookmakers. Okay. Mr. Mbelati says that he was prejudiced by his ban. What do you say to that?
Again, we went through a process where we had a discussion with Mr. Logart, Mr. Judge Ngwepe, and also Mr. Higgins of the ICC, with Mr. Beck and I. We would then weigh up the evidence that we had and measure that against the prescribed offences or sanctions for specific offences. And the ICC has a database of all sanctions, and we would then compare that to see that it's a fair and not too harsh sentence.
Okay, then you make concluding remarks from paragraph 324. I'm going to leave it to you to decide which ones you want to emphasize.
I'm hoping that I won't be too laborious. I'm going to try as quick as possible. I'm a bit exhausted, so if you'll allow me to read from that, I'll be as quick as I can. Mr. Ahmed, I really feel that the allegations that the players had made before the SJN, based on the evidence that we had uncovered and that I presented today, in my opinion, is a misrepresentation of the fact. And that they have perjured themselves because they testified under oath before the Commission. Several of them had made affidavits in the investigation. Some of Mr. Becker will probably deal with that. Some of the oral evidence compared to the written affidavits also differ from each other. So I feel it's very unfortunate that they would have used this platform of the SJN, which I feel is very important for cricket in South Africa and also for players. As the Ombudsman has alluded to, the terms of reference really was to investigate discrimination against players, systemic maybe within the game. for these players to use this platform, which could have been used to investigate and deal with players who had genuinely been discriminated against, I think that is very unfortunate. And for us who had investigated this, it had been over a period of 20 months, where it really took its toll. I think that is very unfair. Thanks.
Yes. I see that
Today was just...
Well, that's what one can expect from 300 and something.
And today was just a summary, sir.
Affidavit, yeah. Yeah, we are at almost 5 o'clock, because we are at just after 4:45. I don't know, Mr. July, how many questions do we have? You don't know.
It's a couple of seeking clarity questions. So we can decide whether we use the 15 minutes, which I'm not sure if I'll be able to cover the 15 minutes, or we resume in the morning.
What's your availability?
I'll make myself available.
I'm available.
Okay.
I'm also available.
Yeah, perhaps it's been quite exhausting for you, certainly for me to keep up with.
It's been 2 years now, sir.
Well, I was not there in the other. Well, you know, other than this hour.
But I must say I'm thankful, sir. I just had to get closure and deal with this in a factual way.
No, look, that's, as I understand it, I mean, everything I've read in the terms of reference, in the objectives of the ombudsperson and what have you, this is exactly what this entire thing is intended to achieve. And my approach has always been that, in as much as there may be an emphasis as to who become the victims,
exactly, sir.
Of you know, of what happened in the past, there is a sense in which the irony becomes one where even the perpetrators are victims, in a sense, if what manifestly or what the victims are alleging turns out to be manifestly inaccurate, untrue, because then the alleged perpetrators become the victims themselves of what has been said about them, which is why even within, as I always say, the strictures of time that this project has unfortunately been compelled to act within, an opportunity had to be provided for everyone, especially those who have been mentioned to their detriment, to rebut allegations, to explain where allegations need to be explained, and also to give me the opportunity to reflect at the end of it all what I make of the evidence. It is a pity that cross-examination, even limited one, largely because of the time within which the CSA board, within their wisdom, decided this entire project must be concluded within. Cross-examination was not an option, even a limited one. Because it would have assisted, the distillation of the evidence. But the least that could be done is for for those who told me that they were victims of unfair discrimination on a race base, and to a small extent on a gender base. As I say, the least that could be done would be to hear those who make the allegations under oath, and then to hear those who get affected by what they said. And of course, the headache is going to be mine to make a judgment of where truth lies. And it's not a task I'm looking forward to with any enthusiasm in the circumstances. But, one has to do what one has to do. So,
we both
it's been a long, you obviously took some time to consult with your legal advisors, and not only consultation, putting the affidavit together, and preparing to come to these proceedings. Let's then deal with it tomorrow morning. I am tempted to say at 9, but
I'm available if the Ombudsman wants to
I'm not available
prevent
at 9. I'll be available at 10 o'clock. Yeah. And I'm sure we will.
Okay.
It won't be long. We're adjourned until 10 o'clock tomorrow morning.
Thank you.
Thank you.
Advocate, you left already.